Let us pray. Dear Lord, we call upon you to give us the motto from the state of Georgia today: wisdom, justice, and moderation. In your name, amen.
I have to be at mine at 4:30. So what we're going to do is we're going to start out with House Bill 30. We've had a number of meetings on that. And I'm going to then move to House Bill 271. That will be hearing only. And then over to House Bill 275. And then I'll pick from the remaining bills and the remaining time that I have, see how far we get. So with House Bill 30, I welcome the author, Chairman John Carson, and ask you to explain to us the change. One thing we got to do. Do I hear a motion to remove House Bill 30 from the table?
So moved.
Is there a second?
Second.
Second. Okay, we have a motion and a second. All those in favor say aye. Aye. All those opposed? All right. Let's do that again. All those in favor, raise your hand. All those opposed? All right. It is off the table. And Chairman Carson, if you would go ahead and explain the changes to the bill.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. First of all, I wanted to say just thank you for your patience. Before we even get to the bill, just thank you for your patience and your perseverance as we work through the bill. This is an important issue. It's an important issue to a number of people in our community. Since the last time we had this bill before your Judiciary Committee, Mr. Chair, we had an act of what I would call uncalled for anti-Semitic behavior 2.5 weekends ago, something like that. And I just appreciate the committee's indulgence and patience to move this through. House Bill 30, I'm working off of LC, I hope I'm correct, LC 491334S. 491334S, is that correct? So what we've done here is, with the chairman's help and Chairman Leverett, Representative Kelly, Vice Chair Reeves, and Representative Stacey Evans and others, we've added a few things and made a few things more clear in the bill. We have added, if I can just skip around a little bit, I hope that's okay. Just to add a little bit more levity to exactly what we're talking about in regard to the IRA definition, we've identified that on lines 88 through 91, this is the same IRA definition that was incorporated in the federal executive order issued by the former president in December of 2019. We also, on line 86, instead of calling it a working definition, we're referring to it here as an advisory definition. On lines 67 through 69, we're also making it a crime or committing an offense of a terrorist act, as noted on line 64 of existing code, adding the if someone were to use anti-Semitic imagery such as a swastika or other types of symbols with the intent to terrorize another, their household or their property or their public property, that would be deemed a terrorist act under this this bill for your consideration. Those are some of the major changes. After consultation and various meetings and so forth, just to give it a little bit more oomph, a little bit more specificity and use in a court of law. So again, I appreciate everything the committee's done to see this through.
All right. Any questions for the author of the bill? All right. Who's got it? Representative Bruce.
I'm still trying to, first of all, again, I don't have a problem with coming up with a definition. I'm still not seeing the definition what we just have in front of us now, unless I'm missing it. I see a whole lot of stuff, but I don't see, here's the definition of anti-Semitism.
So
Okay, and then the other piece of it, I'm still trying to understand how this does not violate the whole concept of freedom of speech. Again, if you want to define anti-Semitism, that's fine with me. The notion that the Jewish community is the only one going through some of these things. I have in our paperwork something that happened last week at a church in Southwest Atlanta. This church is a black church. It's got the same symbol. It's in your package if you haven't seen it. It's the same thing. And again, I am not for anyone being harassed, anyone being going through this, your community or mine. Right. I'm just trying to understand how this is worse for you than it is for me, because I don't see it that way. I see this being just as hateful, just as horrible, and if I'm covered under current law, why are you not covered under that same law? That's all I'm asking.
I regret that occurred, Representative Bruce. What I can do is answer your two questions. In regard to the definition, that is referred to in lines 86 through 91 in the bill on page 4. And what this does, it refers to and adopts the internationally recognized definition of anti-Semitism as adopted by IHRA, International Holocaust Remembrance Alliance, as of a certain date. And that's very key, May 26th of 2016, because we're not subjugating our legislative authority. We're tying it to a definition as of a certain date. And that is well laid out, and it's been adopted by 6 states by statute, 22 by resolution, numerous entities, 3 departments within the U.S. government, thousands of other governmental entities. In regard to your second question, in regard to freedom of speech, that is covered and protected in this bill through lines 102 through 107. So this bill does not come into play unless there is a crime or discrimination. And furthermore, in lines 102 through 107, it says here, and I don't like reading bills in front of a committee, but I'll just read the first line. Nothing in this code section shall construe or diminish any or infringe upon any right protected under the First Amendment, including freedom of speech.
Mr. Chairman, one other thing, if I could. If it's already defined in the language that you are referring to from 5 years ago, or whatever it was, if it's already defined, then what is the purpose of this bill if you're telling me that this bill is to define it?
This is to make sure that by Georgia statute, we're defining it for discrimination and crimes here in Georgia.
Okay. The definition that we were referring to from years ago, that definition gives the courts something to use now. Is that correct?
That's not my understanding, because anti-Semitism is not specifically identified or defined in our Georgia code.
Okay, so what you're saying is you just want to take what was defined 5 years ago. I keep saying 5. I don't know what it was.
6.5.
6.5 years ago, and say that that's the definition
for Georgia.
Okay, so if that's in this, those 3 or 4 paragraphs that you just defined, and that's what the purpose of this bill is, what is all the rest of this doing if it's not infringing on other rights? If the purpose of the bill is to define it, and it's defined in these 3 or 4 paragraphs, what is the rest of the bill doing?
Those various things that I mentioned. It defines state agencies for which this applies. It protects the free speech that I identified through rows or lines 102 to 107. And we make it a terroristic, if I can say that, Mr. Chairman, terroristic act to use a swastika or other types of similar pro-Nazi imagery with the intent to intimidate, terrorize, so forth.
Thank you.
Representative Crawford.
Thank you, Chairman. And thank you for your testimony. I have just one question on line 66, page 3, as well as line 68 on page 4, the phrase intent to terrorize. If you could tell me how that could be determined, the intent to terrorize.
Well, that basically goes to what a judge or prosecutor is going to look for. They're going to look for intent in a court of law, in a proceeding. They're going to look for intent, and so what they're going to do is they're going to look at a defendant's statements, memberships, their literature, their possession of literature, their own writings, graffiti, and all that kind of stuff. What this does, what the IRA definition does, is shows a prosecutor or a judge exactly what anti-Semitism might look like.
And thank you. Follow up. Is it your understanding that a judge without this bill cannot already do that?
That's my understanding.
Okay.
Not with specificity and clarity.
Okay.
Right.
Who's on 13?
Oh, yeah.
All right, Representative Kelly.
Thank you, Mr. Chairman, and I want to just make sure we're clear. We've really done two things in regards to the original legislation you brought to us. Correct. We've tried to kind of narrowly tailor some of the original language you brought to us, and that's kind of what we see starting in Section 3. Correct. Some of it in Section 1, but Section
Yes.
1 and starting at 3.
Yes.
And then there's a new section, Section 2, which creates a new form of criminal penalty. It's in Title 16, the criminal section. Isn't that correct?
I'm sorry to interrupt. It is a new crime. I don't know that we set out a penalty, but
The penalties will come with the new crime.
But the new crime, yes.
And so, I think we can all agree, and Representative, this is disgusting. This is despicable, and this is exactly why we need this legislation today. Because right now, under Georgia law, this is criminal trespass. In Section 2, we're making clear that any time you use a swastika or other Nazi paraphernalia on any type of public property, that it can be classified as terroristic threats, regardless of whether it happened on a synagogue or it happened on the church in South Fulton, or if it happened at the Baptist church that I attend in Cedartown. Isn't that correct?
Yes, that's correct.
And so with that would come enhanced penalties that would apply to the despicable people that do this, regardless of the type of structure it's put on. And so I think the situation that we've referenced here is exactly why we need this new crime, and we need these enhanced penalties. So thank you for bringing us the example.
If I may, Mr. Chairman, one of the problems is people put up swastikas and then tell us it's not anti-Semitism. And I think this committee heard testimony from people defending that ability or what have you. And clearly it's anti-Semitism. And this goes to providing a definition of anti-Semitism with regard to what is accompanied with that, which is some sort of crime or discrimination.
Okay. Any other questions?
What was just said.
Representative Bruce.
Again, with all due respect, like I said, I have no issue at all with defining. But this church, and I know what you were attempting to do, and it was a nice try, but the reality is that I'm trying to figure out, there's no Jewish people in that church. None. And so somebody putting that sticker, that information on there, I'm not sure that that's just hate, period. That's not necessarily targeting the Jewish community by putting that on a black church, like you were trying to imply just now. But what it does, it says that that symbol to the Jewish community is anti-Jewish, and I get that. That same symbol to my community is hate, period. And there's no additional violation put on it associated with my community because they use that symbol. And again, I'm not against what you're doing. I'm just saying that I think that this would be a better bill if it was applicable to everybody that was being harassed. And to tell me that if I say something against Israel, that I'm I keep getting that word screwed up, but
Anti-Semitic?
anti-Semitic.
Okay.
That, and then if somebody says the same thing about Nigeria, it's not. There's nothing wrong with saying it about a different country. And that's the challenge that I'm having with all of this, is to tell me that this is not violating my right to free speech, even if that speech is not desirable to somebody, it's still a violation of your free speech. And that's the issue that I have with what we're doing here today, is that we are saying it's okay to say these things about the other 300-400 countries in the world, but not about Israel. And I wouldn't say it about Israel, but the fact that if I saw a need to, and you tell me that if I do, that all of a sudden I'm committing an additional crime, that is a violation of my rights of freedom of speech. Thank you.
Representative Kelly.
Thank you. And I just want to be clear, and I appreciate always the dialogue me and my friend get to have in this committee. But just to be clear, Representative, Section 2 has no qualifier as to anyone's faith as a precursor to being able to bring that charge. If this legislation passes the House, passes this committee, passes the House, passes the Senate, gets signed into law by the governor, and then somebody does this again on again my Baptist church or the Baptist church that's just happened out in South Fulton, there's no qualifier in Section 2 that it's only in regards to anyone with the Jewish faith. The qualifier is with the intent to terrorize. And I think, a synonym of hate is terrorize in my mind, and I think most judges will consider it that way. So we are allowing prosecutors the ability to go after individuals that want to do despicable acts like this with enhanced charges in Section 2 of this bill. Now, I understand what you're saying in Section 1, Section 3, and the following, but Section 2 will provide for enhanced penalties and a new crime for people regardless of where it takes place in Section 2, and I think that's a very important piece of this legislation.
If I could just say something, Mr. Chair?
Yes.
Representative Bruce, it's my understanding that what happened at that church, I don't know if that's your church, and I regret wherever it happened. I regret that it happened. I understand that it might have been done to intimidate any kind of Jewish relations with that African American church. But listen, Representative Bruce, whether it happens at your church or at my church in East Cobb or in Esther Panich's synagogue up in North Atlanta, these are despicable acts. It's hatred, and it must stop. Okay, no matter what we do.
Representative Evans.
Thank you, Mr. Chairman. Chairman Carson, just wanted to clarify that my understanding is correct with regard to the bill. Someone, after we hopefully pass this and it passes the Senate and signed by the governor, someone can stand up on the courtroom steps and say as many terrible things about Israel or the Jewish people as they want. And unless and until that person also goes and fires a Jewish person or attacks or assaults a Jewish person, this bill has absolutely no impact on what that person said or did.
That is 100% correct.
Thank you.
All right. Any other questions? Any discussion?
I hate to keep going with this, but there was a situation that we talked about outside of the committee. Today, somebody, I'm just making this story. I put the swastika up on something, anything. And tomorrow, you run into my car. I don't know you from a hole in the wall, but you run into my car, we get out of the car, and we get to battling because you put this dent in my car. And then it turns out that you happen to be Jewish. And yesterday I put up a swastika. So now, the fact that you and I are out there battling because we're fighting in the process of us fighting about this car, I find out that you're Jewish. Am I now committing a crime, a hate crime, because you and I are fighting? Because I popped you upside the head for hitting my car?
I don't believe so, because you would have to first know that I'm Jewish, and second, you'd have to be committing an intentional crime. Me hitting your car or you hitting my car and not knowing either one of us, that doesn't really come into play.
Which goes back to his question about the definition of intent. I don't know. We don't know. You could very easily make it up that I'm doing this because you're Jewish. All I'm getting at is that I just think that this bill is still not to a point where it serves the purpose that you are saying that it's supposed to serve, which is just to give a definition. It does a lot more than just give a definition. And that lot more is what I'm concerned about. Thank you.
Chairman Smith.
Thank you, Mr. Chairman.
It might be the other,
Might be the other.
whichever one it is.
This is 16?
It is? Okay.
Yeah. My hot? Okay.
Yeah,
All
there
right.
you are. You're on.
Representative Bruce, under that fact pattern, you would not be in violation of this statute. This is, if you'll read in line 67 with me, it says that it is used in an unlawful manner. So you just putting that sticker up on your car, riding around with it, you would not be in violation under that hypothetical you just gave us. Just want to be clear. Innocent conduct, although tasteless as it may be, is not made criminal under that provision. Just want to clarify right there.
Did you hit it again?
Trying to turn it off.
All right. Any other questions? Or any discussion among the, well, let's see. Do I have a motion? All right. Have a motion, a second. Any discussion of the bill? All right, hearing none. All those in favor of the bill say aye. Aye. All those opposed, like sign. All right. Bill passes. It'll be on to rules calendar now.
Thank you, Mr. Chairman, very much. Thank you, thank you.
All right.
Okay.
Representative Bruce?
Mr. Chairman, I just want to go on record. I'm not sure what the process is yet, but I want to go on record that we're going to, if I can, I want to do a minority report.
Okay, understood, and we'll look into that and get that set up.
Okay, thank you.
All right. All right, at this time, I'll call House Bill 271. If the author's here, Clay Perkle. He's in the hall? Okay, yeah. Yeah, thank you.
Thank you so much. Appreciate it. Thank you.
What did they congratulate you for?
Only got one job.
You're just a good guy.
I'm just a good guy.
All right. Chairman Perkle, we're calling House Bill 271. This will be a hearing only at this time. And if you would, tell us about your bill.
Thank you, Mr. Chairman. HB 271 is a business-friendly bill. It does not add any language. The only changes are in taking out the direct action, which is the important part of this bill. It takes out the direct action language in 2 areas of Georgia Code. So it's my understanding, I've got a bunch of lawyer friends on this panel, and you know much more than I do, but it's my understanding that traditional common law rule provides that a plaintiff does not have standing to bring a direct action against a defendant's insurance company unless there is an unsatisfied judgment against the defendant by the plaintiff. That's a lot of words. But Georgia has one exception to this rule, and only one. I think it specifically and unfairly targets trucking firms via these 2 direct action statutes. Repealing direct action does not limit a plaintiff's ability to seek compensation for injuries involving an accident with a motor carrier. It does not. It simply removes the insurance company as a named defendant from the caption of the case. Now, I understand why some would oppose this, and I think I'm pretty confident that I have some opposition to this bill, and I don't blame them. It is to their advantage to have as many named defendants, particularly highly liquid ones, in their cases. It's why my buddy, who's a cardiologist, when he goes to get fertilizer for his farm, he never ever pulls up in a nice truck and scrubs. It's always in his work truck and farmer breeches because he wants to pay the fair farmer price and not the inflated cardiologist price. Repealing direct action statutes simply brings the motor carrier industry in line with every other industry in Georgia, where an insurer is not subject to direct action, and the 46 other states who do not allow direct action. We're one of 4 that allows this. And from a non-lawyer point of view, admittedly, to me it comes down to a fairness issue. I think it's unfair to be named as a defendant when you've done nothing wrong. I think that's something that I could sell to my constituents. I think it is unfair, patently unfair, to be named as a defendant when you've done nothing wrong. So that is the bill. That was a long way to get just a few lines X'd out, but that's the bill, Mr. Chair.
All right. And I see you have a guest here with you. Is that correct?
You know, they told me that there's going to be a full committee. There's going to be a lot of folks here, and I've got somebody that I trust more than anybody to get my back. He's been in the firing lines a lot of times to the commissioner.
Commissioner, if you would introduce yourself and tell us what you think about the bill.
Thank you. Thank you, sir. My name is John King. I'm your insurance commissioner. You know, thank you, Judge. I appreciate the opportunity to come. I know this is unusual for the insurance commissioner to come before this committee. And back in the day, I used to run operations in South Baghdad in the old area of Old Babylon. And so I now know how Daniel felt when he went into the lion's den. So hopefully you all will spare me some bloodshed. But I wanted to talk to you. As I campaign across the state, this was the number one issue in Southwest Georgia and South Georgia. Small trucking companies, young veterans that wanted to start in the trucking industry cannot get insurance. We're one of 4 states. Louisiana, which is a wreck. Anybody will tell you the insurance market in Louisiana is a wreck. Kansas and Wisconsin are the only other states that have this provision. And I wanted to make sure that from the marketplace, what I'm trying to achieve is I'm not trying to, this is why this is a department bill. I am not trying to change the whole landscape of torts. That's not my role. Fundamentally, I believe that everybody deserves their fair day in court. As a former police officer, as an investigator, that's a fundamental American right. But when we have insurance companies that leaving the state, we have only 5 companies at this time selling in any significant manner policies for trucking companies. And if you're a trucking company with less than 5 trucks, you can't get insurance. And so you will hear probably a great deal of testimony after that those costs get passed on to the consumer. And so that's what the concern I have as somebody that tries to, I'm the advocate for the consumer, but also trying to make sure that we bring industry to operate and businesses to operate in the state. So through competition, we can manage the costs. This legislation does nothing to cap judgments. It does not make it any more difficult to track down a truck driver after an accident. It doesn't prevent anyone from receiving their fair day in court. I would tell you this has been the number one issue that I've faced as I travel, especially in the logging industry. Our logging industry is being crushed. Since our commerce has changed after the pandemic, the way commerce operates in Georgia, it requires trucks to bring products to our homes now. And so all those costs are being passed on. And that's one of my biggest concerns. The issue is this bill only removes, as the chairman mentioned, you still get your fair day in court. And with this the companies that have left the state, and I've talked to a number of them, they say that they will be willing to return to the state to participate in the marketplace and sell policies if this provision. But until that is done, they're just going to stay away from Georgia. And that's my biggest concern right now, that all these costs are going to be passed on in small companies, which I'm a big believer in, especially veteran-owned companies, can't even enter the marketplace because they can't they can't start a business because the cost of insurance is prohibitive.
Commissioner, do you have an opinion, positive or negative, the economic impact of our current law?
It's having a negative impact. It clearly is showing that the costs are being passed on to the community. And what's happening is the small trucking companies are disappearing from the marketplace. The only ones that could actually operate in our state are large multi-state companies that basically can manage their insurance costs. And I'm trying to be supportive of young veterans that want to enter it. This is a good business. Transportation is a great business, and but I'm also cautious that this bill doesn't get mixed up with other efforts, from other places of trying to revamp. This is the most smallest of impacts that I think we can make to get companies to come back into the marketplace without doing. Or I'm not interested in a whole rehaul of our judicial approach to litigation. I think that's dangerous to go. But I think a small tweak, and this is what I consider a small tweak. I'm not a lawyer, so but I did run a small police department in DeKalb County, and I know the cost of operating not only as a city. I can't imagine what the small trucking companies have to face.
You would agree that this would have a positive economic impact, but do you have an idea of how much?
I can't tell you, Mr. Chairman. I don't want to guess in front of a bunch of lawyers. It's especially the good-looking and dressed one up here in front of me.
All right, that's 4 1. All right, Representative Evans, I think.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Commissioner, thank you for being here. A couple of questions, and I'm Because of the timing, I have to share this little fact with the committee. My dad has been a long haul trucker for as long as I can remember, went out in elementary school, and I'm super proud of him and excited for him because last Friday he hauled his last load home, and he's now retired, and he'll be at my house a lot more playing with my kids. So they're very excited to have Pawpaw Keith there. But I do have some concerns about this bill and want to make sure that when we say that we're protecting drivers, we really are, because I fear here we're protecting companies and insurance companies. And if we're going to say this is a consumer advocate bill, I want to be really, I want to make sure that we're actually doing that. So my first question is, in the opinion of the author and the commissioner, what is the purpose of requiring truckers and trucking companies to have insurance in the first place? Who are we trying to protect by having insurance policies?
Well, so we're protecting the public, consumers, and the trucking companies. Yes.
And if we're trying to protect the public as part of that, why do we want to deny them access to the carriers?
Shall I do this?
Let's give it a shot.
Well, thank you. So I don't think the Venn diagram of your question fully overlaps. I think this particular measure does not take away from the public or the consumer's ability to be compensated for injury sustained as a result of negligence. But there again, would it be beneficial for insurance companies? Yes. Would it be beneficial for trucking firms? Yes. Would it be beneficial for consumers? Yes.
How is it beneficial for consumers?
So there again, I'm not a lawyer, and so I don't know the full range in the legal code. I am an economist, and the commissioner stood here and testified that he's talked with insurance companies that would be willing to re-enter the market if something like this were passed. And I know as an economist, when you add competition, so I cannot go to an insurance company and say, will this drive prices down? But ever since 1776, Adam Smith's Wealth of Nations, we can look and know anytime you introduce competition, we have a lot of history of that. Prices do eventually come down. So it will benefit consumers, absolutely.
One final question, Mr. Chairman, if I might, for the commissioner.
Let me also add, if I'm
Sure.
allowed. The inverse is also absolutely correct. Less companies operating in the state will drive cost up. It's just a matter of economics. Less competition will drive it because basically we'll have a virtual monopoly. Right now we have five companies left. Actively selling commercial, insurance to commercial carriers.
My question to you, Commissioner, and now I need to clarify and make sure I'm asking the right question. When you said that you had talked to businesses in the industry that had left but said they would come back, I thought you were referring to trucking companies. Are you talking about insurance companies?
Insurance companies, yes.
Are there any trucking companies who have told you that they've left the marketplace because of the laws that exist today, and have any of those told you that, well, first of all, have any left? Have any trucking companies left?
I'm probably not the best person. I think there's members of folks that want to testify, especially from the trade organizations, that can probably best equipped to answer that question, and they would have the latest data. I know there's several of the companies that came and talked to me last year about it. They were leaving the marketplace because they just couldn't afford to do business.
Insurance companies?
No, trucking companies.
Okay,
and I've also talked to veterans that want to start a trucking company and they just can't do it.
I would like, and I can understand if you wouldn't be ready to rattle this off right now, but I think, Mr. Chairman, it would be very beneficial for the committee if there are indeed insurance companies that have left because of this bill specifically. I would like to have a list. If there are those who said they would come back, if we change this, I would like to have a list. And especially, I have a special concern if there are indeed truckers that have left, trucking companies that have left, because we do have supply issues, and I do want to make sure that we have those companies here and we have those job opportunities. I want to know, and I think the committee would also appreciate knowing the real people that, if you're saying they're impacted, I want to see at least their names, even if I can't see their faces. And then, last thing, really not a question, but to any veteran who wants to start a business, I applaud it. I know I join those around this table in saying that we want to support it, and I think there's likely many ways that we can support that other than potentially this bill. Thank you.
Okay. All right. Before we move any further, I've neglected, I want to recognize a couple of judges here that are friends of mine. Ken Hodges, Court of Appeals judge, with his daughter Margaret, who's here to learn about the legislative process. And also Superior Court Judge Clint Bearden out of the Northeastern Circuit. Thank you for being here. So with that, then we'll move to Representative Crawford. I think you got number 6, right? All right, go ahead.
Thank you, Chairman, and thank you, Chairman and Commissioner, for your testimony. I have a brief question. One of the things that was discussed is the economic impact. My question is that does an insurance company increase their financial liability because of their coverage, or will it be impacted at all?
Would you repeat that question, please?
Sure.
Maybe rephrase it.
Yes. Being sued directly will not, do you agree with this, that being sued directly an insurance company, it won't increase the financial liability of the carrier? Do you agree with that?
No, I think I would disagree with that.
Okay.
So if I am a named defendant, it does actually, I would think it would possibly increase my liability. I don't know, but I would think it would. Yes.
So, but regardless of the size of
So potential, for sure.
well, regardless of the size of any verdict against an insurance company, an insurance company would only be obligated to pay what the damages are, correct?
The policy limitations, I would think.
Correct.
Yes.
So that would that would go unchanged, and I think that's.
I would think the policy limitations would go unchanged. Yeah.
Oh, okay, and so I guess that my question is that it would not increase. I mean, in the end, you will only pay what your policy limits.
So I have testimony coming from an attorney in just a bit that could address that better. Could I allow that? Could I put a comma here instead
Yes.
of a period?
Yes.
And allow that to come forth in just a bit?
Okay, no problem. Thank you, Chairman.
All right. And Representative Deloach.
Chairman Perker, one quick question. Do you have any idea why this statute came into being to begin with, some condition that existed that caused it to come into being, and if so, does that condition still exist?
I might have to have a comma there as well, Mr. Chairman, but it's my understanding, and this could be wrong. So, I will speak the truth as I know it, but I don't know this for a fact. But my understanding that this has been part of our law since the 30s. So, I'm not aware of why it came, but it's been around for a while.
Thank you.
Representative Bruce.
I thought I heard you say that part of this is to control insurance costs. Is that correct? And if we were to pass this and put it, I guess by the definition, you're putting a cap, I guess, on the insurance. Would the insurance companies, or would you guys encourage the insurance companies? I know the cost you're saying won't go up, but now that they're not on the hook, so to speak, for it going up, would there be some encouragement for the insurance companies to cut back on the policies and cut back on the amount of money that truckers are paying? And with full disclosure, Mr. Chairman, my son is a trucker, so I just want to make sure that's out there.
Well,
Would the insurance costs go down with the passage of this bill?
Well, thank you, Representative Bruce, and thank you for your support of this bill since your son is a trucker.
Don't put those two things together. I didn't do that.
So this bill is not just about controlling costs. No, I don't. I think that is causation and correlation. So this bill will encourage competition, which will drive down costs, but that is not the sum total of it. For me, it really is fairness. I mean, I didn't, this is not, all rainbows and lollipops. What I find is patently unfair is for anyone to be named as a defendant in an action that is, they're innocent. I mean, they've done nothing wrong. I carry insurance for my cattle that might get out because of negligence of not looking after the fence, or maybe I left a gate open, and I carry insurance to cover me for negligence. But if a car comes by and hits a cow, one of my cows that got out, then Farm Bureau does not get named as a defendant in my case. I am responsible. It is my negligence. I have insurance to cover my negligence and for my liability. However, it is about fairness. If that happens to be that I have a trucking company, or your son has a trucking company that he owns, or then not only can he be named as a defendant, but the insurance company as well. And I don't know, that it just strikes me as not being fair. Now, if I was an attorney that wanted to bring more defendants in, and the more people you line up and whoever has bigger pockets, absolutely, I would light my hair on fire and make sure that this didn't pass. But I want to make sure that for me, is part of fairness, and it's not just a control of costs. But I think when we encourage competition, and it's also competition not just for the insurance company, it's also competition that should provide, it eliminates a barrier to entry for our veterans to come in to be, I start off with a trucking firm, and now I've got 2 trucks and 3 trucks. If I do not have the artificial barrier to entry that I would not have if I started the trucking firm in Alabama.
So the short answer to that question is no. Okay.
I forget what your question was, but if you say so, I do believe it.
Representative Kelly.
Thank you, Mr. Chairman, and I'll just admit to y'all I'm a little over my head here with everything we're talking about, so I'm just trying to understand how this full process works. And first, I'll say, Commissioner, thank you for being here with us. Thank you for your service, and congratulations on your retirement. Help me understand, how does the process work when say, the insurance companies, do they have to come to your office to get approval when they want to raise rates?
They have to come and and ask for approval just to enter the state. Every product that they sell, they have to get approval from our office. And so we look at, obviously, the cost, and make sure, first of all, that they have the financial backing so they can pay out claims for the policies they sell. And then we also put some protections there to make sure that, for example, they're not redlining portions of our state, and making sure that they're playing fair by the rules that this body has established for me to enforce. I have some authority on rulemaking, but I'm very cautious about using that authority. I'm more comfortable having that authority start here at the legislative process, where there can be a thorough debate on the merits. And then I have no problem enforcing the rules. I come from a culture that enforces the law. But I'm always very cognizant of trying not to overuse our authority, because previous insurance commissioners have overused their authority. And that's how I became your insurance commissioner.
So specifically though about a rate increase, if they want to have a premium rate increase, how do they do that? Does that just automatically come into law?
No. Private auto, and we're working on another committee on resolving that, and I think we got an agreement from the insurance carriers. They have to come, and what we do is we have them fill out the filing, to show us the model, the data that they're using to and then they also have to show us if they've been an existing company that sold products in Georgia. I want to see their losses. I want to see their experience, how they're playing, and then I look at my complaints. I have any complaints that I have from this company, and we take all that into consideration, and we negotiate. We have a hard negotiations. We don't automatically just stamp approval on every filing that we get.
And I appreciate that, and we are lucky to have you as our insurance commissioner. And I appreciate this conversation about wanting to keep insurance rates low. And I believe, the same as the chairman, that more competition does drive down generally cost. And so I want to ask the chairman, if that's the purpose of the legislation, would you be open to a friendly amendment that would cap any premium increases for the next 5 to 10 years?
Mr. Chairman, I think the all shucks, I don't know what I'm doing here, the way you introduced that, Representative Kelly, I think I own that part, and you shouldn't take that from me.
We're both just simple country boys.
Simple country boys. And so
you got
an
an economics degree at Georgia Tech, so don't be trying to take that. That's my stick in here.
Yeah. I would oppose that amendment. I don't know how friendly or unfriendly that amendment would be. But there again, that's to the will of the committee. I don't have, I would not be in favor of that, but I don't get a vote here.
I'd consider it friendly to the consumer. It may not be friendly to the insurance company, but we're here for the consumer. And so if we're talking about being friendly to the consumer and maybe making it more affordable for carriers and truck drivers, that's where I was thinking it may be considered friendly.
And I agree that would be, but there again, one of the concerns that I have, my bill only takes language out, which I love. I got to tell you, I love taking language out. And adding language, I would need to see a draft before I could say, oh yeah, that's something I could support. But because the theory I do, as to whether or not that should be in our code, I'm not sure that is something that we could that even be constitutional. I have there again. I won't draw on my country roots. I have no idea.
Thank you. I'll work on getting that language in a substitute for you for the next committee.
I don't doubt that, Representative Kelly.
All right, Vice Chair.
Chairman Perkle and Commissioner King, good to see you. This is not a question that I would expect an answer to here. It sounds like there have already been some questions that have been asked that may need some follow-up. But South Carolina and Alabama, adjacent states, I don't know that they're comparable, but Florida, North Carolina, and Tennessee, you've mentioned there are only 5 insurance companies left here in Georgia. I'd be curious to know those adjacent states that may have a different law in this area, the law on direct actions. How many insurance companies do they have? And then let's sort of look at who we have in Georgia, who they have in those other states, and are they different? Are they similar? And that's just something to put out there. And again, I don't expect that to be answered today.
Well, I can give you a partial answer, and obviously we'll get my team to do a little bit more research. I know the companies that have left Georgia, a good portion of them have gone into Alabama, especially the logging industry and the small carriers. And I did not realize how big of a deal this was until I went down to Bainbridge, and I got hit up by several companies that said, look, I can't. And so, and I was concerned there that the potential there was for companies to go be based right over the state line and try to do day trips. And obviously that would be some serious, obviously, enforcement issues that would come as a result of that. But that's the companies the 2 companies that I spoke to have left the state of Georgia and gone to Alabama because of the environment. And our economies, especially when it comes to transportation, are not that different when it comes to Southwest Georgia and Southeast Alabama.
All right.
But we owe you some additional information. Yes.
Representative Silcox.
Thank you, Mr. Chairman, and thank you, Representative Chairman Perkle and Commissioner King, so much for bringing this bill. My brother-in-law is actually a trucker, and he's trying to start a company up, and he has had this very problem. And so I think this is very timely. I think it's a good bill. I think it will bring more business to Georgia, and with more business, it will reduce costs for consumers. And of course, they will still have the backing of those companies in those lawsuits. This won't affect their coverage or the amount that they could recover in a lawsuit, correct?
That's correct.
Thank you so much.
Thank you for your support.
All right, any other questions? I know we have some other folks that want to speak on the bill, so we'll call them up at this time.
Mr. Chairman, if I may be excused, I got to put
Yes,
out
sir,
just
you
a
may.
couple more fires, but
Thank you for coming.
me and my team are completely available to the members of the committee and to yourself to bring any additional data.
Thank you, Commissioner.
Thank you. That is true. I was going to pull that by saying that the capacity of this room did not justify the number of people in here, but I wasn't going to do that. I think another commissioner did that one before, and I don't have blue lights or red lights in my car either. Just for the record. Thank you.
That's good.
Thank you all.
All right, let's see. All right, who have I got? Blair or Ed? All right, at this time I'll call up Ed Kroll.
Thank you, Mr. Chairman.
Yes, sir. Please have a seat. Tell us who you are and who you represent, and then what your thoughts are.
You know, it's hot in this room, but it's hotter once you start sitting here. And I got a feeling this is a day where I'm not preaching to the choir, per se. And I'm not going to read all of this either, I promise. So, thank you, Mr. Chairman. Thank you, members of the committee, for taking the time to hear
Could
this
you
bill.
tap that and make sure it's, there we go. Okay, good.
All right. Thank you. How's that?
You're good.
All right. Thank you for taking the time to hear this bill, and I want to thank Chairman Perkle for bringing this, for taking the lead in authoring this bill, and the Commissioner for his lead in doing the hard research and gathering the data to make it clear that this is a much-needed change in public policy. I think I know many of you, but for the record, I am Ed Crowell, President and CEO of the Georgia Motor Trucking Association. GMTA is a 90-year-old not-for-profit membership organization. And while we count the largest trucking companies in the state, and actually the largest in the nation among our members, I want to point out that 70%, more than 70% of our members are small family-owned, mom and pop, if you will, trucking businesses that operate 50 trucks or fewer. In fact, a lot of them operate fewer than 10 trucks. You know, Representative Bruce, like your son, and hopefully he'll get to the 100-truck range. But yeah. That's exactly the kind of people that are hurt by the existing direct action statutes and that HB 271 seeks to help. You know, those people are often men and women who've risked their personal assets to pursue a dream of building their own business. They may have been professional drivers for someone else and struck out on their own, or they may have just seen a need and stepped in to fill it. Sometimes they're second and third generation operators, members of our community that run small businesses and support their neighbors with deliveries and with jobs. There are a few all around here. Down in Waycross, for instance, there's William Pope, who has 90 employees, started the company and built it up. Mac Guest over in Watkinsville. Out in DeKalb County, we have Larry Sellers and Joe Coleman, who, again, started from nothing, had to make 3 attempts to start a trucking company before they got it, and now employ several hundred people to make those contributions. They're the people who kept the supply chains moving during the pandemic and were right behind first responders whenever there's a storm or flood or other natural disaster. They're the people in the companies briefly recognized from time to time as real heroes, but who mostly just work hard and support the lifestyle that we all enjoy. They are not the businesses and people who should have less legal standing than any other business in the state. But that's the situation they operate in today, and it's really time that should change. The legislative process, you know this, you're often asked, or sometimes you ask, what do other states do? And it's already been mentioned that other states do not do this, do not have direct action statutes. And I would point out to you that they also do not have a problem with their plaintiffs having their day in court and getting compensated when something tragic happens. Georgia policy is wrong on this. 92% of the states, 46, That's about the most math I can actually do. Of the 50 states, treat their trucking companies exactly the same as every other business. That means the overwhelming supermajority, by any measure, think of this as best practice, to not have direct action. Georgia trucking companies are at a real disadvantage in competition from other states. We have these higher costs. Those higher costs hit you when you're involved in interstate commerce. And that alone is worth supporting Senate Bill or House Bill 271. But if we drill down further, the policy picture gets even worse. Not only does Georgia currently allow direct action, but it focuses against one segment of the trucking industry. If you are a private carrier, that is, you carry your own product, and exclusively your own product, and there are private carrier tags here in the state of Georgia, you're not subject to direct action. You're only subject to it if you're carrying someone else's product, if you're a for-hire trucking carrier. That's the only folk that are targeted by this. In doing so, Georgia is punishing for-hire trucking companies for their very existence. The statutes only apply to them and not to any other type of company, even if those companies are running exactly the same kind of vehicles down the roads, even if those companies have exactly the same financial backing, it doesn't apply to them. By any reasonable measure, this is unfair and unmerited. What makes this situation even more untenable is that no one that I can talk to can find a qualitative basis, in fact, for these statutes to exist. I'll digress a little. The question was asked when these began. As best we can tell, they were put in the code in 1937. Even then, there's not a clear reason for why they were put in the code. Some people say it might have been to help find a truck after an accident or after an incident. The fact is, the statutes do not help you find anyone. They presuppose that, in fact, you've found someone because you're naming them in a suit. But regardless of size, companies that aren't for-hire trucking companies are exempt from this. So fixing 271 is good policy, and it's way overdue. Now, I've been discussing this with folk, several of you included, and I've heard some questions or some complaints, and I'm sure we'll hear more in a moment. One of them I heard, which I thought was probably the most specious of all, was that if Georgia's the #1 state to do business, how can this be a problem? Surely it must not matter. The simple answer to that is simply this. The company that does the rankings, Site Selection Magazine, does not rate the judicial environment. It doesn't count it. The judicial system, the judicial environment do not count when they do their site selection rankings. So, end of story there. Another one I've heard is, without this, you can't find the truck or the trucking company or the truck driver. And again, as we've already said, the statutes actually do nothing to help you in that. And you should know there are multiple federal agencies and federal websites. If it was tough in 1937, there's an entire infrastructure to help you find the truck, the trucking company, the truck driver today. The Federal Motor Carrier Safety Administration requires every trucking company to register, to have indicia on the side of its trucks, and to have insurance in place. And also they track the trucks now with electronic logging devices, which track the miles and the hours those trucks operate. So it's not difficult. One of the other strange arguments that I've heard has been, you can't prove that insurance rates will come down. Well, economics and experience tell us they will, but you can't prove something that hasn't happened yet. That doesn't mean it won't happen. And folks tend to push that as proof that this is not worth doing because you can't prove it's going to happen. Well, that's just, again, wordplay. But along the way, I've also looked at what do people who support this law, firms that support this law, what do they say about it? I did a Google search, and in less than half a second had 3,080,000 hits when I asked the question of, is it good to sue a trucking company in Georgia? I won't read you all the answers. I didn't read all the answers. But I looked at several dozen of the websites, and I do want to read you the comments from people, from firms when they are hunting for clients, not when they're arguing that this law should stay in place here. Because when they're hunting for clients, they don't talk about needing to find a truck driver or about 1937 or any of that. They say, for instance, why does Georgia direct action statute matter in a truck accident claim? And this is direct quotes from their websites. After all, the insurance company will still handle the claim. Its lawyers will even take care of the case to court if litigation is necessary. Further, at the end of the process, the insurance company can be held legally liable for paying an unsatisfied judgment. While all that is true, Georgia's direct action statute for truck accidents still matters, and they explain why. With other types of personal injury lawsuits, the jury is never even informed that the defendant has an insurance coverage that is responsible for paying the claim. Remember, a jury is made up of your peers. Jury members are people. Even though a defendant's insurance coverage or lack thereof technically should not affect the value of a personal injury verdict, people are impacted by circumstances of the case. No person wants to bankrupt this small family-operated trucking company. This is why the direct action statute is an extremely important tool for truck accident victims. And they put this in bold. When a jury understands that a giant commercial insurance company is responsible for the damages, they are far more likely to issue a larger, and they put parenthetically a more fair, award. Bringing direct action claims against a truck company's insurer, you will be in a better position to maximize your settlement or a jury verdict. Another website, because there were dozens of these, another one said, Georgia law generally bars a jury from hearing about the presence of or lack of insurance. It's often grounds for a mistrial. The reason? Automobile accidents or any other case should be tried on the merits as opposed to insurance coverage. As a practical matter, we all realize insurance does play a role in cases, but still be very careful about mentioning it. And then they put in all caps, except in truck wreck cases. And finally, just one more. A quote from another website. As a rule of thumb, a jury will be more likely, and they put this all in bold, to award more compensation to the injured plaintiff when a trucking insurance company is named as a defendant in a truck accident case. Now, again, you won't hear that argument here today, but that's what they do when they're advertising for clients, is the promise that what this is all about is you can get more money. It's bad policy to single out one industry and treat us like that when no other industry in the state of Georgia has to deal with that situation. We don't allow direct action against anyone else. Okay? And again, 46 of the 50 states understand this. Best practices is to not allow these statutes and to get rid of these statutes. So I'll conclude and be glad to take questions. Repealing Georgia's direct action statutes will bring the state's treatment for for-hire motor carriers in line with the way we treat every other industry in the state, and it will provide equal treatment for the men and women who choose this industry. Repealing it will bring us in line with the best practices of almost all 50 other states. So I ask your favorable support when the time comes, I know it's hearing only today, for House Bill 271. Thank you, sir.
All right, you have a question to your right.
I'm surprised.
Representative Evans.
Thank you, Mr. Chairman. Thank you for your testimony. I agree with you that it's not hard to find the carrier, the trucking company, because the trucks, they usually have their name on them. Not all of them, but a lot of them do. But just for purposes of my question, we're in agreement on that. But it's not always easy to find the driver. And I think whether you like it or not, we probably agree on that. So if that's really not something that you're looking to keep injured parties from finding, and that is the driver, would you be willing to work on language with us that would make a driver's carrier company responsible in some way for helping injured parties find that person so that they can be named, sued, and served?
I think there's a couple of answers to that, one of which will be Chairman Perkel's commas, because there are attorneys here that might be better able to describe the actual process of finding the driver. I'm not certain, I guess unless the driver's no longer employed, I can see there it would be difficult to find them after an incident. But we certainly want to make sure people have their day in court. I would ask, however, I can't see how these existing statutes help you find a driver. So I think they're actually two separate questions.
But for purposes of my question, if you're saying this isn't about big companies and this isn't about insurance companies trying to get out of paying, and we can always, people that are injured can just sue the driver, and nothing about this statute will change that, and everybody's going to go on their way. But you have injured parties and their attorneys.
Yep.
Let me finish my question.
Yes, ma'am.
You have them saying, we are having trouble, whether you believe it or not. If you take them at their word that they are having trouble finding them, and they take you at your word that you're not trying to keep them from finding them, why can't we work that out? I don't know why that's a hard question for you to answer, to say, yeah, sure, we'll help you find the drivers.
Yeah.
We put them on the road in the first place. We hired them.
I think there's a couple of things there. First, congratulations to your father too, and thank you.
Thank you.
You know, we do not want to do anything to help you not, or help a plaintiff not find the driver that's involved. Be happy to do that. The disconnect I'm having is nothing in these existing statutes actually help find the driver. So to me, that seems like a separate issue. Glad to work on it, but it's not a reason not to fix this public policy problem, because fixing this public policy problem does not create any new issue in finding a driver. And again, this allows the driver, it allows the trucking company to be sued even without direct action. You know, so I guess I'm just not quite getting the connection you're making, but I'm happy to talk with you and work with you about that. You know, in terms of if there's a way to do that better.
Thank you.
Sure.
Any other questions? Seeing none, thank you.
All right. Thank you very much.
All right, we're on to Mike Iverson. Good afternoon.
Good afternoon, everyone.
Introduce
Thank you.
yourself, tell us who you represent, and your comments.
Yeah, so my name's Mike Iverson. I am the president of the Big I, which is the Independent Insurance Agents Association of Georgia. I also sit on a working group that works with ISO, so as attorneys, looking at policy language might be an entertaining evening, right? At the bottom of that is going to be with permission of ISO or copyrights of ISO. So they make those recommendations for carriers on what coverage should look like, along with supporting rates. And one of my roles with them is I advocate for consumers to make policies friendlier for insurance buyers, and most of the time more broad. And so this issue, when you really look at it, I'm going to remind you that our members make up about 83% of the market for commercial auto, so it's sold through independent agents. It's even greater in the trucking firms. I don't know the exact percentage. I'd put it in the 90s, that over 90% of truckers are purchasing insurance from independent agents. So we represent a huge piece, right? And we get paid. By the way, I would have a bias to say, don't fix this law, because I get paid more from it, because it is impacting rates. So why am I here advocating for something that actually means I may get paid less, right? Because I care that Georgia businesses operate. There's a relativity between us and other states. We've chased it for a long time as a state to bring companies to Georgia. And the question is, are we going to keep companies in Georgia when trucking is one of the most important pieces that we have in Georgia, especially with our port and other things? And so when you look at it, and when we look at the numbers, so if I was just to say, in this law, I mean, I think it was underlined very, very well about how it's unfair, really, to a very narrow section of the industry of trucking. And I can tell you from independent agents, as soon as I tick for hire on an application to insurance companies, that for hire box, and by the way, even when I don't check it sometimes, and they find a filing because our guy is hauling for one of the other companies that they own, so it's an internal, but they have to have the for hire, it impacts their insurance programs. How much? I have one that went up 385% as soon as he decided to not haul exclusively for himself, but another one of his companies. How crazy is that? 385%. And the question earlier was, well, what are we like competitively to other states? So I pulled some data. ISO was kind enough to pull some relativity factors for me. So let's talk about surrounding states. South Carolina, they're the closest. We're 33% higher in recommended rates over South Carolina. They're the closest to us in rate. Ours are 33% higher. Alabama, we're 60% higher than a truck in Alabama. We're 71.5% higher than Tennessee. We are 98.8% higher than North Carolina. So I guess I have companies who have attorneys who say, where should you domicile? If you're trucking, it's probably not Georgia, because you want an access to something other than state court, right? I mean, why would you want to do business here? And when you look at the trucking industry, the stats were put up earlier, I think it's 95% of the industry in trucking is firms with 7 vehicles or less. those operators are impacted disproportionately to some of my largest clients. So when I look on a cost per unit, those small accounts are being hammered. I don't see how it's fair. I don't see how two truck tractors rolling down the road, both have drivers who need to protect the public. One gets hammered in a suit, the other doesn't, and one has to pay disproportionately more because of the for hire status, and it really comes from this law that's been in existence since the 30s. So with that in mind, I'd be open to any questions you may have about what we see.
All right. Representative Evans.
Thank you, Mr. Chairman. I'm super inquisitive today. I don't know a lot about insurance. I don't practice car wreck cases, this isn't my field, so I'm learning. And this kind of bill maybe is the one kind that would normally be in insurance, and so we're sort of a blank slate here, at least I am. I don't mean to say what other people know about insurance. But when you tell me those rates from the other states and you first hear it and you're like, well, dang, what's going on? But I want to know more, and I suspect there's an answer to this question, which is why I want to know it. What else goes into determining somebody's insurance rate? Maybe training, maybe education required, maybe how often they check the brakes. I mean, there's got to be way more than just, whatever this statute is that goes into the rate. So before you bring those numbers as a point, I'd like to know more about what the other states look at when they're determining rates and what the other safety and training and all those requirements are in other states.
Sure. So from an underwriting standpoint, I work with several large companies that have operations in states across the United States. And it doesn't matter whether we're dealing with New York, Illinois, which are highly litigious states, California, or the Midwest. I mean, our training and our regimen and recommendations is the same things. I mean, we want to see camera systems. We want as much data as possible, which is hard brakes, hard stops, accelerations. There's a variety of those things. And there are mandates over drivers and driver training. And those are logged and kept. My counterpart with the association can talk about all the things that they do to support their members with training, as does the industry. And so inside of the trucking arena, insurance companies have had a strong desire to try to find ways to control costs in Georgia. And so you had programs that came out that said you're required to use these camera systems. And they'll be part of our program. And by the way, your data is going to feed to us so we have an understanding of what you're doing. And if we don't like what we see, we want to be able to react faster to it with those trucking firms because they're not keeping their drivers and the public safe. And so the industry's evolved into this high data environment that trucks can be monitored 24 hours a day as they head down the road, front and rear facing cameras. There's eye sensing cameras that can tell if you glanced away from the windshield, and it sends out a warning and sends it to headquarters. And so the differences between the states, there are none. It's about risk mitigation. Do we have the safest company possible? And that's what most insureds are working for. And so it doesn't matter whether it's Illinois or somewhere else, those same underlying guidelines are being used across the nation. What you have is jurisdiction issues.
When you say jurisdiction issues, you mean?
I mean that if I was a for-hire trucker in Georgia and I'm looking at the volatility of cases, we have some pretty tremendous awards. There's been some really nice wins for some attorneys and claimants.
If the
terrible deaths.
Yeah. Including farmers. I mean, let's be real. I mean, a truck is a dangerous machine. We can agree on that, right?
Absolutely.
And when it hits somebody, it doesn't just ding them. It most of the time is a catastrophic injury or a death. Mm-hmm. And it doesn't discriminate. Veterans, Democrats, Republicans, farmers, lawyers, doctors are all subject to being hit because we all drive on the interstate. Going back to, you were talking about highly litigious states, if it's all about litigation, does that mean that our insurance rates here match to what other states where you claim are highly litigious states? I think you referenced New York. I was wondering if our rates are the same.
I pulled surrounding states. I can certainly get data on New York and other jurisdictions.
I'd like more information because you can pull out any number. I'm not an economics major like my chairman over here. I'm I'm a fake economics major. I did it in the arts and sciences school, not in the business school. So I only know a little bit about statistics, but I know enough to know that I can pluck out any number I want and make it sound like what I want. So I'd really like to know more about what those numbers actually represent before we make a vote on this bill.
All right, any other questions? Seeing none, thank
Yeah.
you. Oh,
Yeah.
hang on, got one. Representative Holcomb, go ahead.
Thank you, Mr. Chairman. I'm trying to figure this out too. I don't practice in this space. I'm a lawyer. I've never done a car accident or med mal or any of that stuff. But I handle really complex cases across the country, and I'm curious in terms of what are the factors that are driving up the cost. And firstly, this is just to remove it for intrastate carriers, not for interstate carriers, correct?
It's the for hire status. So this impacts for hire status.
Right, within Georgia, not within other states, correct?
Yeah.
Okay. And what are the deductibles typically on companies that do this? Like, can you give me a range of what the typical deductible size is for
You mean
an accident?
on a liability basis?
Yes.
So for your small truckers, most of the time, they won't have a liability deductible on their auto liability for somebody who's running 3, 4, 5, 6 units, which is the vast majority of the marketplace. If you're talking about large companies, so when we work with the jumbos, many times we're setting up a captive structure or something where we're taking on the first $1 million in any one claim, and we're pre-funding it through our own mini insurance company, essentially. So we set that up kind of behind the scenes, even though it looks like an insurance company to the consumer. I don't know if that helps. So large companies are going to be self-insuring usually that first 500,000 to $1 million.
Okay. But there's no deductible for the small companies?
No, because in general, a small company, if you gave them a $500,000 deductible, it probably wouldn't be good for the other party because they don't have that $500,000 in cash to cover the deductible.
Right.
So there's a financial ability that then comes behind it. So when you buy into large deductible programs, you're essentially collateralizing those. You're putting up letters of credit to make sure that you can cover those debts. And most of these small companies, they're lean.
Okay. And give me a range of what the policy premiums are.
Yeah, so in general, most of the rates, a competitive rate right now in Georgia is probably around $10,000 for a liability, $1 million in a year. Most of your smaller operators, sometimes that drives up to about $17,000. I've seen as high as $40,000, but that's an anomaly.
Okay.
Per truck
Per truck.
for the first $1 million.
Okay. And then what's the usual exposure when there is an accident?
Well, that one I have a hard time quantifying because obviously if it's a bus load of, it probably no different than a personal auto accident. I mean, how big is that personal accident going to be?
Okay.
What'd you hit?
Yeah, I mean, what I'm trying to figure out is what everybody is saying is that we're an outlier, we're an anomaly. And is it just this policy, or is there other factors that are contributing to that? And I'm having a hard time seeing how the cost for just the policy itself would be different, because more likely than not, whoever is defending the carrier is likely also defending the company. So there's not two sets of lawyers, and I can't imagine the legal work is much more for doing that. There's probably joint representation, or is that assumption a false assumption?
So the answer to that is, I guess I'm going to take it two different directions. One way I'll say this, which is direct action against the insurer, brings the insurer also in to potentially pay, as though they played a role in the accident itself. So the assumption underneath this is that the insurance company played a role and could be sued above and beyond policy limits that they've provided for their insured, as though they performed the action. That's what makes it an unusual carve-out. So in other words, the bank financed your vehicle, but you crashed it into somebody. Is the bank brought into the lawsuit because they helped you buy the vehicle for liability? That's what's happening, is insurance companies are being sued. So you may see a trucking firm being hit for policy limits, and then the insurance company then paying far and above that because they are also a named defendant in the suit, as though they were operating the trucking company themselves.
Okay. Since this is not my area of law, I have a hard time understanding how they could be bound by something that's greater than the contract. Can you explain that to me?
This particular doctrine in law and the way that it's been utilized in the court system. I can point to cases, and I
Okay.
can give you some of the cases on where that's held victory.
So it's just through case law that the insurance carriers are held to a higher limit than what they have for the policies with the carriers to begin with.
Indeed.
Okay. Yeah, I would like to.
And as you
to
can
see
imagine, an insurance company in general, I'm not here to defend insurance companies, but I am to say that they believe when they sell a policy for $1 million limit, that their limit will be $1 million. And if they act in bad faith, well, guess what? They're going to get dinged for bad faith too, as they should. So I get involved often with clients to say, hey, here's what we'll do for action. But when you tell an insurance company, offer $1 million policy, but it could be unlimited based on the court's findings, I guess if you're a company that works with numbers, why would you want to do business in an environment that does that? That decides your contract no longer matters.
Okay, I hear you.
Thank you, Mr. Chairman. If you'll indulge me with just a couple questions. The questions Representative Holcomb was asking, are you referring to the verdicts outside policy limits? Are you getting into what we call bad faith litigation when awards have been made outside that, or what are you?
I don't look on it as bad faith litigation. I don't really want to get in the way of bad faith litigation. What I do think is unfair is naming another party in a lawsuit who has no liability in that lawsuit. I do think that's unfair.
Can I ask another one, Mr. Chairman? Did you say in Georgia right now we're mandating front and backwards facing cameras as well as this
No.
eye sensing technology?
No, I didn't say it's mandated.
Well, you were saying it's just being implemented?
It's being more and more adopted. It's being recommended. It's being pushed by insurance companies to say, hey, these are all good practices that you should have to monitor your vehicle. So the goal of insurance company is to make losses predictable. Obviously, they need to make money. I always say bulls make money, bears make money, but pigs should get slaughtered, right? And that's where brokers come in. We're going to move business if we think companies are overcharging, et cetera.
So, are you saying that those types of things, forward-facing, backwards-facing, this eye screening technology, it makes things safer, it makes it more predictable to insurance companies? That's what you're saying?
I think evidentially it can be powerful to show negligence, and evidentially it can be powerful to show that the driver did everything they could.
And I think that's what we want here, right? And I think having those types of processes implemented, do they help keep insurance rates lower?
The answer is statistically, we have seen a slow downtick in some of those instances where it's involved. It increases the volatility when it shows a driver at fault, right? So I'd say that what the industry is convinced of, for the most part, is that these are good practices, and we believe it's the way of the future. So most of the time, you're going to see risk managers looking to implement things into fleets that like this to try to control losses and try to make things clear on what took place in an incident.
And so, if I'm hearing you correctly, that it's good policy to have these implemented. Should as policymakers, should we look at maybe requiring some of those things on trucking if it will help keep insurance premiums predictable and maybe even drive down costs has been proven?
Well, I think what you're now looking to do is expand from the ask of today. So my goal today was to come and say, hey, all I ask is just stop discriminating against for-hire trucking. I mean, it's a simple ask for me. I mean, I'm hopeful that you guys will look and just say, you know what, it is unfair. We should help for-hire trucker. for hire trucking? Why are they being hurt disproportionately compared to other types of trucking firms? Outside of that, you can certainly, pursue. That's why you're here.
Would that
right?
would that type of mandate help predictability for insurance rates and drive down premium cost?
That alone, I can't speculate that alone solves the entire problem, because you're asking what drives down insurance costs. And what I say is there's a lot of things that constantly change insurance costs. And I'll use pollution as an example. In the 80s, we didn't even have an exclusion for pollution on liability policies, but we do now, right? And so as soon as the federal government changes the pollutant barrier per billionth particle, it changes that entire marketplace. So sometimes courts shape policy in ways that I can't predict.
Okay. Thank you.
Representative Crawford.
Thank you, Chairman. Very briefly, to the extent that a company or an insurer goes bankrupt and an accident occurs, what recourse would a victim have, if any?
If the insurance company goes bankrupt?
No. The company, the motor carrier company.
Okay.
If they go bankrupt or become insolvent.
So the bankruptcy of the insured client to an insurance company does not change the obligation of the insurance company, meaning they still have an obligation to make that party whole. And in Georgia, virtually all of these are statutory coverages. The majority of carriers you're going to see are part of guarantee funds, et cetera, that also then even back up the insurance company even further. So the answer is it doesn't. The bankruptcy of a trucking firm does not negate the obligation of the insurance company to make whole that claim.
But you would agree with me that when bankruptcies occur, it is difficult to collect from those companies?
From the company, yes. From the insurance company, no. I would disagree there.
I meant the company.
Yeah,
So.
yeah, sorry.
Okay. I don't see any other questions, so thank you, sir. And Georgia trial lawyers, who we got speaking today?
Start.
Thank you, Mr. Chairman.
Yes, sir.
I'm Dan Snipes. I'm a lawyer in Statesboro. I was president of Georgia Trial Lawyers Association in 2019 and 2020, and since that time, I've represented them at the Capitol during the legislative session. When I kind of go at the end, I've kind of got some things I want to say, but then I also want to try to address some questions that have been asked. So if I get off track for a minute, I'll ask for a minute indulgence. But I want to start by saying, why does Georgia have the direct action statute, and what purpose does it serve? I think that's a very important starting place for people to understand, and it's really, really simple. But in order to initiate a case against someone, you don't just have to locate them, know where they live. You have to be able to serve process on them, and then you can file a complaint and you can name someone as a defendant, but they don't have an obligation to answer the complaint until you serve process on them. And the very nature of tractor-trailer work is that it's transient, and particularly as it relates to an owner-operator. And when I say an owner-operator, we're talking about one of these smaller outfits that's just one person in one truck or one person in a couple of trucks. Well, if an out-of-state trucker is delivering a load in Statesboro, and he's from Mississippi, and he causes a wreck in Statesboro, and then I initiate a lawsuit against him, well, I go to his house in Mississippi and have a process server go there. Well, he may be in San Antonio that day delivering goods. And because he didn't want to have a deadhead, meaning just an empty trailer going somewhere, then he picks up a load in San Antonio and he takes it to Oklahoma City. And then from Oklahoma City, he goes to St. Louis, and then he goes to Chicago. And he's not there that week because he's earning a living. That's what they do. Well, he comes by on Sunday and visits his family and, gets his clothes changed out, but then he's headed out on the road again. And it can be very, very difficult to serve a driver of a tractor trailer because they're transient by their nature. And likewise, smaller companies, because that's the company, can be very difficult to serve. So direct action exists so that an injured person can serve someone to be a party to the case. That's the reason it exists. The insurance company has to put on notice. There are websites now. It used to be you have to file a certificate with the Public Service Commission in Georgia, but now you can go to and look online and say, yes, I understand that for the Mississippi company that they're insured by this company, and you can identify they've got a registered agent in Georgia, and I can serve them, which may not be the case. Now, so the statute exists so that an injured Georgia citizen doesn't miss out on a day where they can't bring a case, because if they can't serve the driver and they can't serve the company, the insurance company still has an obligation to defend, and their defense is going to be a motion to dismiss for lack of proper service, and they're not going to pay the claim. They're going to allow them the legal defense that they're entitled to under 911 4 and 6, I think. But they're going to raise those defenses. I promise you they are. So the statute addresses a very real problem. And unlike the situation like when Chairman Perkle was presenting his bill, well, if his cows get out in Turner County, I know where he lives because there's a farm there. And it's a different circumstance because farmers aren't transient. And if you hit somebody on the way home from the Capitol tonight, you've got an address and you're not transient. But the unique nature of tractor-trailer drivers is that they are, in fact, transient. Now, the rationale that was the biggest rationale that was given for y'all as to why this is a good policy is to try to increase competition in Georgia. But and it's particularly, I think, related to smaller companies. But when we get into that, we get into some really complex problems. And one of them is that large tractor-trailer companies are doing to small tractor-trailer companies what Walmart did to the mom-and-pop mercantile store or to the hardware store in your hometown when you were growing up. They're using economies of scale by being able to lock in and have less volatility on fuel prices, lock in contracts to make sure they get to haul more and more goods, and then pay drivers higher wages, that they're using competitive advantages to then run smaller businesses out. And then once a small business maybe has a good driver and they're paying him a very fair wage, but then a private carrier like Walmart or a big company like Koch Brothers or one of the other national SAIA or one of those big companies comes in and offers them a 50% raise for doing the same thing, they can't hold on to these drivers. And there are real economic disadvantages to being a small trucking company. This is being overblown, and it's getting the blame for a lot of other economic realities that exist. One of the things that y'all addressed, and this goes from me being a trial lawyer and brought direct action cases. When you name the insurance company, you're naming them as issuing a specific policy of insurance to the insured. And their liability, in that case, is limited to their policy of insurance. It doesn't create some magical other pot of money. I think Chairman Perkle, admitted this. A direct action statute doesn't make it have more money. Whatever the policy of insurance is, it is there. And you're not making it greater in any stretch. The insurance company doesn't have more risk. So when these companies are looking in Georgia and they're saying, okay, we're trying to assess what risk we have. I'm going to get into a little bit more about why Georgia may have different premiums than other states. But insurance companies are very, very good at assessing risk based on the liability. Is our insured at fault, or can we blame the plaintiff or some other party? And what's the severity of the injury? And insurance professionals, they make their decisions based on those two things. And that's what they base their decision on. Now, to make a big deal about insurance should be named as a party, well, jurors are already qualified as to insurance because you have to find out if jurors have a financial interest in the case. And just like I need to know if a juror is an officer or director or a shareholder of a defendant, if there's an insurance company that's in the case, depending on whether it's a stock or mutual company, I get to qualify the jury as to that because we need to know if they've got a financial interest in the case. And it's really disingenuous to say, well, because people know there's insurance, the value of cases go up, because people already know there's insurance in every case that involves a collision. In fact, in any case where there is insurance, jurors are qualified as to that. So when you look at where we are there, we look at, how these companies do this, and they're really basing this on valuation of cases. Now, when you look at our neighboring states, Georgia does have some unique things. Georgia has Atlanta, which is far more populous, has far more motor vehicles, far more tractor-trailer traffic than any other urban area in the Southeast. The Port of Savannah is the busiest port in the Southeast. I'm personally aware and professionally aware of some of the tragic collisions that have occurred on I-16 involving freight going up or down I-16 one way. In the 28 years I've been practicing law, there have been very, very significantly more collisions in the past 6 or 8 years on I-16 that are horrible collisions. And I really had a hard time with somebody characterizing those as nice wins. Because I promise you, when you're talking to the kids' parents, that ain't a nice win. If I could do something to cut back on those collisions, I'd do anything in the world I could. But what we don't need to do is make it more difficult if, for instance, as one of our members told me, in a case he's got right now, where the driver's somebody who is completely sketchy and the trucking company has folded up. And if he can't bring the insurance in, he's not sure he's going to be able to collect anything. And that's for a collision happened on I-85 north of here. But there are differences. One thing about North Carolina is North Carolina has a state-funded reinsurance program, which means insurance can set off their risk. They're not bearing all of it. Right now, you can buy reinsurance, but there's not a state-funded program. And there are differences between Georgia and North Carolina. Georgia and Tennessee have completely different civil justice systems. And that's one of the things Commissioner of Insurance said he didn't want to get into. Didn't have a chance, and off the top of my head, big differences between South Carolina and Alabama. But I know the ports in the city of Atlanta are obvious differences between the states as it relates to what risk are repricing. But at the end of the day, y'all are being asked to make a policy decision. And the policy decision is there are going to be some circumstances where you can't find anybody to serve because of the nature of trucking sometimes. And are we going to put the injured party or the parents of a deceased child in a position where their case ends because they can't perfect services or not an insurance company that's identifiable? You know, sometimes when you're an outlier, maybe you're an outlier for the right reason. And maybe Georgia put this in place since the 1930s for a very good reason, and there's a reason we've not taken it away. One other thing, I do want to mention this because it goes back to why it's hard on small companies. They talked about technology, cameras everywhere, sensors to see where you're looking, and that's where a lot of those collisions on 16 are drivers that are distracted for whatever reason. That's primarily, I mean, there's the young man that worked for Kelly Loeffler, the school principal from Dublin, the Georgia Southern nurses. Those all appear to have been distracted drivers where a tractor trailer hit another vehicle from behind at a very high rate of speed that had slowed for traffic in front of them. But bigger companies have an advantage when they're buying insurance because they can afford these things more easily. None of the things y'all are being asked to do are going to address those concerns. Nobody's sitting here telling you premiums are going to go down. The hope is that you can create competition. Well, there's a lot of other ways to create competition, and that's something that needs to be looked at. And I promise you, I've met with Commissioner King to talk to him about this. I met with Chairman Perkle to talk to him about this. And I would love to see there be more competition. I'd love to see there be more horrific truck accidents. But what I don't want to see is when a citizen of Georgia needs to bring somebody into court, and because they can't find a driver who's an owner-operator or works for a small company that's, you know, sketchy, that they're left out in the cold. That's what I don't want to see. And that's the reason why Georgia's got a statute that needs to remain in place.
I think it's Representative Hong.
Thank you, Mr. Chair. Thank you, fellow Georgia Tech economist, chairman, for bringing this, and fellow Dan trial lawyers. Now you guys know I'm not biased in asking this question. Mr. Snipes, so you are stating that this is usually, and I have not used this statute, but this is only during if there is a service issue, correct? That's being used, or are plaintiffs' lawyers using this for every trucking?
Well, I think plaintiff
case?
lawyers make a decision given the facts and circumstances of each case. But the last time I used it, that I can remember that I used it, was dealing with the circumstance in the Southern District of Georgia, which, because of diversity of citizen issues, jurisdiction was in the Southern District, where it was a New Jersey company, I believe, and an out-of-state driver, and I chose to include the company. Now, in that circumstance, there was one lawyer, one law firm, but one primary lawyer that represented all three defendants, and, you know, and without getting into it, then once you get in, I found out a few things I didn't know once we got into discovery. But so I don't know if that answers your question. But I didn't do it just for service in that case. But those are cases where I'm trying to highlight, if you can't perfect service, you don't have a day in court.
Okay. So do you know just approximately percentage-wise how often this statute is being used?
I don't. I do know that it's not used in every tractor-trailer case. It doesn't have to just be private carriers. They're not used in every common carrier case or for-hire case. They're not used in every case. And, I mean, lawyers make different strategic decisions based on, you know, what they feel like is best for their case.
And is it, and one last question is, so unlike what Representative Kelly was talking about, we have the bad faith. So this does not increase the liability amount, correct?
It does not. I mean, okay, so when you're bringing a case and you name the carrier, you're identifying the policy, and you're saying that you're not saying that the insurance company has liability in the case because of any bad act it committed. You're specifically pleading that it has liability under its contract of insurance, and you're identifying the contract of insurance. So when you do that, you're tying yourself that insurance company, that's its exposure. That's what you're tying yourself to when you plead the case, because its liability is based in contract. I mean, essentially, that's what you're dealing with.
Okay. This is not an area I've ever practiced in, but I'm a little confused about being able to track down the driver to stay in court. We got 46 other states that do it differently. So how does that work in the other states?
First of all, it's tracking them down, okay, but it's also putting a process in their hand, okay,
Right.
And then you get into, well, are you lawfully affecting process? You know, if I can serve somebody by leaving at the regular place of domicile with a person of suitable age, but if the person doesn't have anybody living with them that's of suitable age, I may not conserve them. I don't know. Not every state has the same service of process requirements that Georgia do, but they're all generally similar. But some states make service of process easier.
Okay. So if we made that kind of change, it may do away with this?
It could. I mean, like I said, I've been practicing now 28 years, and service processes remain pretty much the same, other than you can waive it now. You used to couldn't waive it as easily, but service process has been pretty much the same the whole time. And, you know, I think because by and large it works, and this has been the same for a long time.
All right. And also in tort law, can you not exceed the policy limits with a demand letter?
But that's the bad faith scenario, okay? And that is, but the bad faith there is, the insurance company has an obligation to protect the assets of its insured. And if I make a demand within the policy and the insurance company chooses not to pay the demand and not protect the assets of the insured, then when I get an excess judgment against the defendant, then the defendant can assign his bad faith claim against the insurance company to me to satisfy the judgment against you, and then I get to go pursue the bad faith claim against the insurance company.
So, and that all depends on what the amount is
Of the verdict. But that's only if you take the case to a verdict, get a judgment in excess of the policy limits, and you make a demand within the policy limits.
Okay. All right.
The bad faith, though, is key to the duty that the insurance company owes to its insured.
Thank you. All right. Any other questions? Seeing none. Thank you.
Thank you.
We got that. Blair Cash. All right, sir. Introduce yourself, who you represent, and what you want to tell us.
Thank you, Judge. My name is Blair Cash. I'm a partner with the law firm of Mosley Marcinac Law Group in Kennesaw, Georgia. And I would venture a guess to say that 98 to 99% of my practice involves representing truck drivers, motor carriers, and many times under the direct action statute, their insurance companies when they are involved in an accident in the state of Georgia. I handle mostly cases involving personal injury and litigation. I also handle day-to-day advice for motor carriers and insurers, and oftentimes will also help truck drivers fight tickets. Lately, dealing with logs and weights and tie downs and all these things that we're not going to bore you with today. So I will be very brief. I know we've been here for a while talking about some very difficult things, and I want to raise a couple of things. Anytime there is a loss of life on the roadway, it is horrible, and we would all like it not to happen. And defense lawyers get cast in this bucket of being callous and, having this attitude of being not understanding of when those types of cases happen. Those cases affect me as well, and I want to go ahead and put that out there. There were a lot of questions about bad faith and what does this do for this statute. In no way changes the bad faith landscape in Georgia. It in no way affects an insurer's duty and obligation to settle claims presented within its policy limits. That doesn't have any effect here. I think there were numerous questions about finding a truck driver and finding the person that needs to be served with a lawsuit in order to take that case to trial, in order to get fair recovery for a plaintiff. A couple things on that, and Judge, I believe you touched on this. Many states across the country have similar service rules. They allow for service upon under the Non-Resident Motorist Act in Georgia, where you can serve the Secretary of State and then serve an out-of-state resident by certified mail by Federal Express, and that counts as service even though you did not physically hand a copy of that lawsuit into the hands of a truck driver. So I believe the service argument, it can be difficult tracking down some truck drivers who are transient. It can be difficult tracking down some motor carriers who maybe no longer in business, but I believe that argument is easily disposed with. And second, talking about, and I believe it was touched on, and I forget who mentioned it, but one thing that has changed significantly since this act was allowed in 1937 is obviously the internet. And nowadays we can get on the FMCSA's licensing and insurance website and find out exactly the name of an insurer of a motor carrier, their policy number, and importantly, whether they carry something called an MCS 90 endorsement. I'll talk about that in a minute. And then you can find out when the policy period was for that particular insurance company's policy, and what their authority history was with the FMCSA. So I talked about the MCS 90 endorsement. The MCS 90 endorsement, because I believe there's been some talk about what happens if a motor carrier goes bankrupt. What happens if they have no assets to recover? What if the insurance company is playing funny business and trying to deny coverage and things of that nature? Well, an MCS 90 endorsement applies to cover motor carriers who have purchased their insurance in the private market and when they operate in interstate commerce. So to give you an example, let's say ABC Trucking has a policy with XYZ Insurance Company. XYZ Insurance Company denies coverage to ABC Trucking because John Doe, who is driving for ABC Trucking, was driving a vehicle that was not listed on the policy. So in that particular instance, you might think, oh, well, there's no way that the injured party can recover, and in this case, that's just not true. The MCS 90 endorsement allows an injured party to recover against the insurance company, and provided that they prove that the motor carrier was operating within the scope of their authority, that they were the carrier responsible for the load, and that is often met by the placarding and signage requirements that we have that are enforced by our Motor Carrier Compliance Division. So a couple of other things that I wanted to address. Speaking just anecdotally from some of the cases that I handle, many times, and I believe, sir, you brought up this point about the same lawyer is oftentimes representing the insurance company, the trucking company, and the truck driver. That's not always the case. Sometimes it is, but in the cases where you see different lawyers involving or representing the insurance company, the motor carrier, and the truck driver, then you drive up litigation costs. The cases become far more complex. They clog the dockets, and those cases become unwieldy to handle, both from a plaintiff side and a defense side. And I think it's important to remember that repealing the direct action statute has no effect on an injured party's right to recover. It just removes the insurer as a named defendant from a case. Judge, when you were on the bench, I'm sure you, the first question that's always asked when a jury gets a case involving civil damages, what's that question? Well, does somebody have health insurance? Does somebody have liability insurance? So I think this law will remove the insurance company from the caption of the case, and it will bring the treatment of for-hire motor carriers in line with every other business, every other person, every other entity doing business in the state. And first of all, and then lastly, I'd like to thank all of you who have family members who are in the trucking industry. I have 4 kids that I need to put through college and pay for, and it's because of your trust and your generosity in allowing me to do what I do and bringing everything to us that I'm able to do that. So thank you very much. I'll welcome any questions that you might have.
Any questions from the committee? Representative Holcomb.
Thank you, Mr. Chairman. Can you give me circumstances of when there would be separate counsel? I'm having a hard time understanding why that would be. What would be the conflicts that would prevent
So
somebody?
it would be a legal conflict of interest. So let's say, for instance, a driver claims that he wasn't hauling for a particular carrier at the time the carrier says that he was. Many times you see it where a driver is distracted by a cell phone, unfortunately, or a driver tests positive for drugs and alcohol after a wreck. You might see separate counsel for the driver and for the company in that instance. So you'd see it in that context.
Okay. Is it fair to say that that would happen irrespective of this issue with the insurance company? So in other words, whoever is representing the insurance company is probably still representing the carrier, so that work is still getting done. Yes or no?
Perhaps.
Okay.
When you get into the bad faith context and you see a policy limits demand to settle that claim and the insurer decides not to meet that demand, many times the insurer will hire separate counsel to represent the interests of the insurance company, because in that instance, arguably, you could see a motor carrier, their interest being adverse to that of their insurer because of the potential negligent failure to settle claim. And I think, so I hope that answers your question.
Yeah, it does. And I'm still trying to understand it, because this isn't my area, but I'm trying to understand what is the driver of the increased costs. And then we heard different testimony from the last 2 witnesses in terms of this contractual issue of, is the liability capped at the insurance or is it not? Did you speak to that? And if not, can you?
I'm a lawyer, I'm not an actuary. So I'll answer that question first to the extent that I can. Repealing the direct action statute does not change a policy's insurance limits. It doesn't. That rulemaking authority rests with the Federal Motor Carrier Safety Administration and whether they decide to increase the minimum limits required to operate interstate for hire on the roads of the United States. You can throw a rock on the internet and find out that the size of an average verdict increases or exceeds the minimum amount of coverage that is required to operate as a for-hire interstate motor carrier. That is obviously not what we're asking this body to do. That's not within this body's purview. One thing I think that bears mentioning is that in the case law that has developed since the direct action statute was in place, is that the case law allows an injured party to maintain 2 lawsuits, one against the truck driver and the motor carrier, and then one against the insurance company. 2 separate lawsuits, 2 separate venues, proceeding on different tracks that ostensibly could result in a double recovery. So you asked the question of whether that increases defense costs, whether that increases premiums because they're having to defend these claims. I think that answers that question right there. I'm sorry I didn't mention that earlier.
No, that's helpful in terms of the joinder issue, but is the carrier, if named through this direct action, is the cause against them for the contract with the carrier, or is the cause against them some other tort claim that opens them up to greater liability? I'm trying to make sure I understand that part.
When you're talking about the carrier, do you mean the insurance carrier?
Yes.
Okay.
Sorry.
No, that's all right. I just want to make sure we're speaking the same language. So an injured plaintiff's cause of action against an insurance carrier of a motor carrier is one sounding in contract. That's what the case law says.
Okay, so it would be capped to whatever the policy limits are?
Correct. And
Okay.
then in that instance, the insurance company, let's say I've had cases where in the event of a catastrophic loss, the insurance company pays out the full amount of their policy limits, and then that cause of action proceeds against the motor carrier and against the driver. And then the insurance company is thereby dismissed.
Okay. So individual liability continues against the individual for any assets they may have beyond what the carrier covers?
Depending on the terms of any settlement that's reached between the carrier and the injured party, yes.
Okay. I'm getting it. Thanks.
You're welcome.
Representative Silcox.
Thank you, Mr. Chairman. Thank you for coming today. I was just curious about, I'm not familiar with MCS 90. What is that? That's not my speak.
So it is an endorsement required by the Federal Motor Carrier Safety Administration for motor carriers that are operating for hire interstate commerce. So to receive operating authority under the Federal Motor Carrier Safety Administration, you have to prove as a motor carrier that you are that you have met the financial responsibility requirements. That's a lot of words just to say that you have to have enough money to cover any losses that your company or that your driver might cause on the roadway. That can be done a couple of ways, either through self-insurance, through purchasing a surety bond, which isn't as common anymore, or purchasing a private policy of insurance from one of the number of insurance companies that write those types of policies. So it's that third instance where the MCS 90 endorsement comes into play, where even if the insurance company denies coverage, even if the accident happens involving an unlisted vehicle, even if the policy is canceled, and the policy is canceled before an accident happens and a motor carrier gets involved in an accident, that MCS 90 endorsement remains intact and available for a set amount of time until it is canceled with the Federal Motor Carrier Safety Administration, such that MCS 90 could apply to provide a recovery to an injured party in the event of a loss.
So you said this only applies to interstate carriers, so it would not apply to short hauls, correct? Just within the state, it would be interstate, multi-state.
That's correct.
Okay.
And then, but in the intrastate context, motor carriers are required to file certificates of insurance with the Department of Public Safety. So there's to use a bad word, since we're talking about insurance coverage, there's coverage there.
So it's almost like reinsurance, is what you're saying, kind of? Kind of, to back up?
You didn't come here for a lesson on MCS 90, I assure you.
Right.
But in a way it is.
Okay. I guess I'm thinking, if you can't find the driver or they disappear or what have you, there could still be a suit, right?
There could be. And really that has nothing, that MCS 90 endorsement would still apply if you can't find the driver. Because I will tell you, I spend a lot of time finding truck drivers myself. And whenever I'm in a position to acknowledge or waive service on behalf of a truck driver, I do it. But that doesn't mean if you have trouble finding a truck driver, you can still assert vicarious liabilities against a trucking company. You can still have ways to serve the driver, like what we talked about with substituted service, with service upon the Secretary of State, and other ways to locate the driver as well. So.
Okay, thank you.
You're welcome. Thank you.
All right. Any other questions? Thank you, sir. Appreciate it. All right. I think that's all the witnesses we have on that bill. Thank you, Chairman. Any last words you want to give us before you step out?
It will be absolutely quick. I have had 3 bottles of water. I'm in my mid-50s, and it is hot as it could be here. But I did want to clarify one thing. So one of the witnesses that gave testimony mentioned something about disingenuous and how the increased competition is the reason for this bill, and it's really not for me. I won't say disingenuous. I'll say I may have been misunderstood. The actual purpose for this is the fairness thing, and that to me is so. All of us, I don't know, all of us. There's a number of us in this room probably had parents about like mine. So I had a brother that's 1 year younger than me, and he and I got into a lot of scrapes together. And if mom and daddy didn't know who was responsible, we both got a whipping. And that's kind of what I'm looking at here, except here one of the brothers is still at church. I don't know why he should get a whipping. It bothers me that someone could be named as a defendant who has not caused a harm. And I think to the chairman's point about finding the driver, so that was the number one thing that those who voiced opposition to this bill said was finding the driver is kind of difficult. And to the chairman's point, I don't know how they do it in the 46 other states that they don't have this statute. And lastly, when I was, I've been married to my lovely bride for 35 years this year. Amen. Amen, brother, if you only knew. But we'll trade stories later. 35 years. I got married after my junior year at Georgia Tech. And so going into my senior year, I was broke. I mean, I was poor as Job's turkey. And I could not pay my tuition. And I go into the financial aid office at Georgia Tech, and I had my hat in my hand. I said, ma'am, I'm married. I got 2 quarters left, and I don't know what. My mom and daddy ain't got the money. I ain't got no money. I don't know what I'm going to do. There was a lady whose name was Connie Kugel, and Miss Kugel found me grants and loans that put me over the top. And I graduated from Georgia Tech owing $750 is all I owed because of Connie Kugel. Fast forward 30 years. And so that name I've thought about for this 35 years. And fast forward 35 years. And I was able to track down Miss Kugel. Even though she changed her job, she changed her name, and she moved across the state. I don't know a lot, but I was able to find her. And the number of quality lawyers that we have on this committee it's indicative of what we have through the state. I absolutely trust you'll be able to find the drivers and their defendants. But thank you for listening. Thank you all for your consideration, and I'd appreciate the positive vote when it comes up. So appreciate it. Thank you.
We'll be in touch with you soon. Thank you. All right. Call House Bill 275. Chairman Powell, I think, was standing just outside. Chairman Powell, thank you for your patience.
Well, Mr. Chairman and ladies and gentlemen, I hope y'all have had enough blood this afternoon. You'll take mine as the way I want to present it.
Whenever you're ready.
All right. I think you have a substitute LC 393756S that you're working from.
No, we don't have that.
Well, then, what do you have, the,
We have the 393699, which is the original bill.
well, then I'll go back to that. Thank you, Mr. Chairman, ladies and gentlemen. This bill comes to y'all today, and understand, this isn't necessarily a committee that I like to haunt around. And probably the most telling is that from the 2 hours that y'all just spent on the last bill. I have a constituent up in Franklin County that runs a trucking company. And in conversations with him, in speaking to him, he's told me that some of the issues that they had as a small trucking company. And a lot of this deals with the survival of their company. And it deals with the insurance companies and how they have to report if a truck driver, somebody with a CDL or commercial license comes to them, that the insurance companies ask the first thing for a life history. When they file for the MVRs, they want to go back until the driver came out of the womb, quite frankly. They want to know the whole history. And, you know, in my years up here, we've always had a standing rule. There was always a limitation on looking back over people's driving records and such. And if you'll take a look at this bill in the on line 16, let's see. On line 16, the federal requirements mean the number of years that a commercial motor vehicle operator's driver's record that a motor carrier or department is required to investigate. The federal requirements are 3 years right now, and that's what we're proposing. If we ever find the substitute, I was going to recommend that we go down a few lines and make a language change to say that it would be whatever the federal requirements are, or 3 years, whichever is greater, just in case the feds ever change those requirements. The second part of this bill deals with the GPS. A lot of the, as a matter of fact, a lot of the operators today, they have GPS monitoring devices on these trucks. They monitor everything from time on the road, or especially accidents, anything that may happen, speed and such as that. A lot of states, they don't have this, don't have the regulations, but as I understand, if you look at on line 2122 or 2223, that any vehicle global positioning system data or video shall be limited to the date of the accident or a moving violation occurred. The reason for that is because in Georgia it's not limited. Other states are. So what a lot of these companies are doing, they're just taking them off. So they're running without those GPS devices, basically to be sure insurance or for any other evidentiaries may not ever be able to catch up with them if they don't have them. So what we're saying is that we go in two paths there. One is the insurance, that they can only look back to the federal requirements of 3 years. And the other would be that any of the GPS data would be limited to the date of an accident or the moving violation.
All right, y'all are, I think, just now getting a copy of the substitute. I'll give y'all a minute or two to look at it, and then if you have any questions for the author of the bill, ring it up. All right, Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. On lines 22 to 23, toward the end of the bill, I think I understand why you might want to have some limitation there, and certainly if it's causing these things to just be gone, that's not what we want. But are you open to some language that video and data would be available, 24 hours before, 24 hours after the violation, as opposed to the date, so that if there's an accident at 1 a.m., then I've only got an hour, even though what happened 2 hours earlier, even though it was a different date, might very well be relevant.
So my good friend, I'm at the mercy of this committee. Y'all are the attorneys and the legal brains to this. Whether I agree with it or not, doesn't make a whole lot of difference. That's the reason I've always tried to avoid Judiciary Committee.
Well, it matters to us, Mr. Chairman. If we can agree on it, I know we'd like to, so I was just curious your
The
thoughts on
other
that.
ones, quite frankly, it's always been my attitude that most of the attorneys that serve on this committee, they know law better than I would. I didn't mean for this bill to look like it got into tort reform. I would rather cut my own throat than to come forth into something like that, because I know what you're getting involved with that. But in listening to my constituent, it's getting more and more difficult for them to deal with the insurance companies to stay in business. And knowing our situation on the carriers today, it's hard enough to get employees, hard enough to get drivers, and basically the pitfalls of trying to run a trucking business is not like it once was.
And unlimited look back is probably causing problems in hiring?
Yes, sir.
Okay. Anything else, Representative?
No, thank you.
All right. Representative Kelly.
Thank you, Mr. Chairman. And I guess just my question is if an unlimited look back is causing a problem, is it because maybe the guy's just a problem driver? And shouldn't we put some considerations on, 3 years, 4 years? Is it an arbitrary number just in general, or?
I have no arbitrary number in this. What we came up with, and Leg Council drafted this for me, and and it looked pretty good to me that, go back to the date of that accident or an infraction.
I may come back with some questions, Mr. Chairman. Just.
Yes. Any other questions? Is there anyone here to speak on it? Oh. All right. All right, thank you. There's some other people signed up to talk about it, and if you want to just have a seat right there, we'll get them up here. I'll start with the Georgia trial lawyers. Mr. Snipes, are you coming back up?
Yes, sir.
All right.
I will.
All right, and just so everybody's on the same page, we're now looking at LC 393756S.
Yes, sir.
All right.
So, and I guess I'm just going to kind of break it into two sections. And the first part I'm just going to talk about on the sub. I'm going to focus on lines 20 and 21 to start with, and then I'll talk about lines 22 and 23. So under subsection B, parts 1 and part 2. So to start with, when you look at the federal requirements for what a trucking company has to do when they hire a driver, and then what they have to do once the driver continues to work with them, we're looking at two different sections of the Federal Motor Carrier Safety Act, which are in the Code of Federal Regulations under Title 49. So one is under 49 CFR 391.23. When a company hires somebody, they've got an obligation on that regulation to get a 3-year MVR on the person that they hire. And then under 49 CFR 391.25, they've got an obligation to update that every year. But in the guidance that is published by the Federal Motor Carrier Safety Administration, the guidance goes far further than just those two requirements. And specifically in a guidance that was issued in May of 2020, and it's Federal Motor Carrier Safety Act, FMSCA-DQ-391.25-Q001. So I'm just giving you the citation because I'm fixing to read to you what the way they do these in the Motor Carrier Safety Act is the agency poses a question and then presents the answer. And the question is, to what extent must a motor carrier review a driver's overall driving record to comply with the requirements of 391.25? And the answer that the federal requirement that the federal agency gives So when they're saying this is how we apply our own requirements, says the motor carrier must consider as much information about the driver's experience as is reasonably available. This would include all known violations, whether they are part of an official record maintained by the driver's licensing authority, like an MVR, as well as any other information that would indicate the driver has shown a lack of due regard for the safety of the public. And that goes on to say, that includes violation of traffic, criminal laws, as well as, so it gives a little bit more detail. So the first part is what I want to say is, the statute is drafted, and this is not in any way a knock on alleged counsel, because they're trying to say we want to follow the federal requirements. Well, the federal requirements are much more expansive, I think, than anybody fully realizes that they are. So I don't know that what we're doing here provides the relief that anybody may want out of this, because the guidance from the Federal Motor Carrier Safety Administration says you got to look at everything that's reasonably available, including their entire history of violations. So if we're, when we defer back, and we can't preempt this federal statute, Georgia can't say we're going to ignore it. So we're kind of bound by that. So I would start by saying that while I certainly understand where Chairman Powell's coming from, and we just talked for a minute ago about why smaller companies are having such a difficult time finding drivers, getting insurance, and I do think both of these bills we've talked about fit into a broader picture of how insurance premiums are priced and how you create more competition in Georgia for insurance and make it better to have, make it easier for smaller companies to hire drivers. But I don't think lines 20 and 21 do anything because of what the Federal Motor Carrier Safety Administration says about their own regulations. All right. Then that's where I am on the first two. So then going to lines 22 and 23. This line would be a huge fundamental shift in law, beyond the question that Representative Evans asked about just 24 hours. Drivers of these trucks are required to keep logbooks. That there's a maximum number of hours they can drive. There's a certain amount of rest that they have. Well, GPS data is one way of making sure they're being honest in what they say they put in their logbooks. The other part of this, GPS and video, but you get into of if the video explains why the driver's not paying attention the next day or 2 days because he's been on a bender, he's been doing things he's not supposed to be. What you're doing is we're taking otherwise relevant evidence and just excluding it. And for both the driver history in a civil case or for the second one, judges always have to weigh the probative value of the evidence versus its prejudicial effect. And you're looking at prior violations. Well, a seatbelt violation is not going to be something that would be relevant in a civil case, but if you've had prior, reckless drivings or not paying attention and doing things, that might be relevant in a case. And we already have judges that weigh these things. Likewise, a judge is going to have to weigh how relevant is this data we get from a GPS or a video against, what does it help prove versus its prejudicial effect. But what this bill would do is just say you can't ever consider that regardless of how probative it would be and how relevant it would be.
Let me ask you, does that conflict with federal law now, that part?
Right now, there's things that have to be kept. The federal statute doesn't say what a finder of fact gets to consider or not consider when determining liability.
Okay.
So that's the difference. The federal statute, the federal regulations are, these are the things we require trucking federal motor carriers to keep in a driver qualification file, to do an investigation before they hire a driver, to keep this data about hours and those kind of things. When they don't follow those regs, that's certainly evidence that parties consider relevant as to whether or not a party was negligent, but that's up to this body to determine what's admissible in Georgia.
Okay. So the federal regs don't require a global positioning system.
They're not required, and that gets into, though, because it gets into the more technology that companies can use, then insurance companies view them as, being safer. So when you get into if companies are ditching them, well, then their insurance companies' premiums are actually probably going to be less the more technology they have, because that's the way to monitor people to make sure they are, in fact, being safer.
Gotcha.
So this is, and I am very cognizant. I hate to feel like I'm the person coming into a room saying no, no, no. But for the reasons I've set forth, I don't think lines 20 through 21 do what the chairman wants them to do because of the Federal Motor Carrier Safety Act. And then secondly, 22 through 23 would be just, it would be an enormous shift into evidence law in Georgia. So we'd ask for a do not pass.
All right. Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Snipes. I wondered if you could comment on the potential interplay between this bill and the bill we just debated, House Bill 204, because what you just said sort of made me concerned that if we do this and we're making less surveillance available, we're saying it's okay for you not to check into driver's records, then we are going to have insurance premiums go through the roof.
Well, this doesn't prohibit companies from having GPS or video. It would just prohibit a lawyer from using it in court that would otherwise be relevant if it doesn't fall within the same calendar day. So it would not, that part of it would not. And likewise, what we're talking about, and I'll go to line 18, this is just for purposes of establishing liability. So this just means that if I determine that a trucking company should have done a background check to find out that, and this is one of the examples I talked about with one of my members that does a lot of this work. If a driver's really bad, he may get put on the sidelines and he has to go do another job. He may have to be a trial lawyer for 3 or 4 years to let his driving record get clean. And then once he's tired of being a lawyer and going to court, then he gets back behind the wheel. And that's I'm trying to use that as tongue in cheek, but he could go do something else. So for 3 years, a person could have a clean driving history because they've been out of the industry because they were forced to take a break. And then what this would say is when you get back on, and even though this person had a really bad wreck 6 years ago and had other citations, that you can never use that. I mean, this would be an exclusion, and so that's kind of one of the other problems you have here. We do need to find ways to get more drivers for this person. But what this is saying is when people do things that hurt somebody, we're going to make it more difficult to hold them responsible. We're not addressing how do we right now for a CDL, you got to be 21. Well, if somebody decides they want to be a driver and they work and they complete a technical school program, maybe there's things we could do where we could get them behind the wheel when they're younger. And, and maybe there's ways to get them safe, because that's the idea is when they're 21, they're going to be a little bit more responsible. But maybe there's training things that we can do and to make more drivers available and to make them safely trained in a way that it lowers premiums. This just doesn't accomplish those goals.
Thank you.
Representative Silcox.
Thank you, Mr. Chairman. Thank you so much for coming today, Mr. Snipes. My question is, I think that this does go to proving or not proving a pattern of activity on the part of a driver, like you said, and if there's a pattern or their habits that would make that person vulnerable. I agree with you that I think this is a problem. And I think it would be a very important probative part of the case to prove patterns.
Well, and I think you make a great point, Representative Chairman. How does this interact with our current rule of evidence 404 that generally limits prior bad acts unless you can establish a pattern or habit? And this statute would appear to say if that pattern or habit goes back over 3 years, you can't ever get into it, regardless of how probative it may be.
Thank you.
Okay. Representative Jones.
Forgive me. Speaker Rawson found out I went to law school and passed the bar, and for that I pay my penance. You said something that was pretty interesting to me, because sometime either in 2018 or 2019, there was a bill inside of this committee where the discussion around the admissibility of seatbelt wearing during an accident, and it was just the opposite answer that your organization gave, which was limited in terms of the probative value of that versus Chairman Powell's bill speaks to limiting. You're now saying that having greater data, and look, as a tech guy, I get it. Look, I would, I'll leverage tech all day, but it seems to be incongruent, the answer that was given 3 years ago or 4 years ago versus on that bill in terms of wanting less in terms of information regarding, I'll say, the safety structure and what was occurring during that accident versus I'll say, the probative value of having days or weeks or months of GPS data and other telemetric or telematic data that you would get typically off of an 18-wheeler or any type of commercial truck. So without taking too much of the committee's time, could you maybe just kind of give me how that incongruency can be lined up?
Certainly. And without seeing the exact language of that statute, but I've seen other statutes over the years.
Mm-hmm.
So the first thing we're talking about is, though, what's probative of helping to determine the cause of the collision. All right? And one of the things, whether or not a person's wearing a seatbelt or not wearing a seatbelt, is not probative of why the collision occurred. That would be things like, does a person have a history of driving distracted? Does a person have a history of speeding? What does the data show about, now with electronic data recorders in automobiles, and depending if the case warrants doing the download, there's a tremendous amount of data you can determine about what caused the collision. So then you get into the second aspect, though, of when you go about talking about assessing, damages. And that's one of the things, generally, because the seatbelt evidence is shifting the blame for what occurred from the party that caused the collision to the party that suffered the injury. That's something that over time it's been determined that's very prejudicial to the injured party. And there's a lot of things to get into that, but it's where you're weighted prejudicial. But that's part of the reason why we don't allow evidence of who the officer gave a citation to. We don't allow, like we talked about at length before, we don't allow evidence about the amount of insurance that's available. There's a lot of things that we don't allow the jury to know about because over time we've determined that it's too prejudicial and not probative, and this is probative of the cause of the collision. We're getting into probative as to cause of collision
Right.
versus probative as to other aspects.
Yeah. So I understand the difference between the first part in terms of causation and the second part in terms of damages. But again, the massive inconsistency of here you're saying you want a wide breadth of this committee to say, just go ahead and take that out and basically take Chairman Powell's language and basically expand it into such a broad sense. But on that other side, in terms of prejudicial versus probative, I mean, an individual not taking personal responsibility to slap a seatbelt on, I can understand is not part of the causation discussion. But in terms of the damages, by all means, you decide not to put a seatbelt on, I believe without a doubt is absolutely cognizant and something that I would want to know in terms of determining what the damages should be, because you failed to do that. I think here we're taking advantage, thank God, of technology advancements in telematics, GPS, and similar things like that. You're asking us to be able to expand that in such a way that you want to create some type of pattern, correct? And if that's the case, I still don't understand the inconsistency, but we can have the conversation out in the hallway if you'd like.
If you'll just give me just a minute, because when you say massive inconsistency, I want to make sure how does that information come to the parties? And in most car wreck collisions that don't involve the severity where you do a download of the electronic data recorder, the information you get as to who's wearing a belt is by what the officer observes when he gets to the scene. I was in a collision going to see a treatment physician at Houston Clinic in Columbus, and somebody pulled out in front of me. As we struck, we hit a third vehicle. I saw the person in the third vehicle was very badly hurt, had to bust the door open my arm and go to the person, wave somebody down to call 911. When the arresting officer got there, I was sitting in the back of the car I had been driving and wasn't wearing a seatbelt because I did what any of us are going to do when there is a wreck. And if you're physically able to go check on somebody, you're going to go check on them. And then you're left to what does the officer find when he gets there? And if you're moving around, well, then do you tell him so I'm just trying to let you know that the proof of that is a very inexact science. And what you wind up doing is then, and in that circumstance, I wasn't wearing a belt when he got there. And how does he know I was wearing a belt? And quite frankly, I wound up and fractured my kneecap and realized I was in bad shape, and I never talked to him about the collision. But so I don't, what did he put down? I don't even know what he put down, but I didn't get a chance to talk to him about it. So I'm just trying to use that as an example of the nature of how proof comes in on that usually doesn't meet the normal standard we have of proof in cases. officer didn't, did he observe? And most of the time, he doesn't observe. So I'm just trying to let you know it's a very complicated question, so I don't think it's a massive inconsistency. But I understand, I appreciate your
But I think
your
we'll
question.
will agree to disagree. I see it as a massive inconsistency because there is technology that gives us that information. I agree with you that there's definitely eyewitness to that, but I think I know there's technology that gives us that. But again, we had that conversation X number of years ago, and there was a disagreement just like this.
Well, because there's two things. One, you have to be able to access the software to download the data.
Yep.
And then you
The
have
box.
someone to interpret the
Mhm.
download. And that gets into the economics of that's just not done in every case.
True.
Because, it's just because that data can sometimes show you a lot of other things, and in the economics of every case. And that's the reason it's a very complex, complicated issue. Thank you for preparing me for Senate Transportation tomorrow.
All right, yes, sir. Any other questions for this witness, I'll call you? All right.
Thank you, sir.
We got next. Steve Molina. Hope I got it right. Come on up. All right, sir, if you would introduce yourself and tell us who you represent and then what you want to say.
Sure. Good afternoon. I'm Steve Molina. I'm here representing the chairman and the bill that's been presented to you. I think you guys have had quite a bit of information on DOT, transportation, and trucking this afternoon. So one of the things I'll mention is my background is in the insurance industry and risk management. So safety, risk management, loss control claims, as well as placement of insurance. I've been in and around trucking companies for quite a long time. For about the last 20 years or so. So in this particular bill, what we're trying to establish here is simply following a criteria that meets the federal requirements. A trucking company that's trying to evaluate a driver, and they're evaluating it via a federal standard of 3 years on an MVR perspective, and then they're having to go back and when they're involved in an accident and they're pulling records that may be 5 years, 7 years, 10 years, or 15 years, puts them in a tough situation as to what is the appropriate thing to do when we're evaluating a driver. There's situations today where you have drivers that are 40, 50 years old that when they were in their 20s or 30s, maybe they did have circumstances and situations with a bad MVR. So should those records that go back 10 years in a different time in their life, maybe going through a divorce, maybe in a certain circumstance or situation that created that mindset or that situation with driving habits, that today is very different. So when you got a commercial driver, their livelihood is driving. So they want to make sure that they're keeping and maintaining a solid MVR or solid background in terms of that 3-year history. So drivers today, if anybody has ever applied to be a driver, a CDL driver for a trucking company, those that have experience with it, it is difficult. It is there is a lot of information that has to be had. So it is the MVR, it's a medical record check, it may be a criminal background check. There's a lot of data out there too, in CAB reports and SAFER reports, PSP reports that's pulling specific information about that driver and with respect to being involved in accidents or things of that nature in that history. So there's a horde of information that's available in evaluating a driver. So it was mentioned earlier about the guidance. Certainly there's a question that comes out to the regulators as to, hey, how should we act relative to these MVRs? How should we act relative to what the standard is on how we evaluate an MVR? So, the guidance is really correct in what he read, because we're using all the information available to us within the federal standard that says these are the things that we need to do. And it's not just the MVR, it's other things that is available. And I mentioned a couple of those. I often tell the trucking companies I work with, you might as well strip to your skivvies, run across the Mercedes-Benz Stadium and for everybody to see, because all of the information relative to your business and your drivers is public record, and it's available and accessible by most anybody. Today, any one of you could go out and look at SAFER, and you could see a horde of information that's available out there on any trucking company in the state of Georgia. So this bill is nothing more than trying to establish kind of the playing rules So how are we as a company going to establish the playing rules relative to how we evaluate our drivers relative to the federal standard, absent of the knowledge of any future accident that occurs that may then result in data being pulled beyond what I pulled under the federal standard, what I'm required to do. So a lot of moving pieces there, but this bill just kind of normalizes it and aligns it so companies know what to do and how to do it, and they're aligning with a federal standard that makes sense.
Okay. Any questions by the committee? Thank you. Thank you, sir.
Yep.
Werner Fox. All right, sir, if you would introduce yourself and who you represent and what you want to tell us.
Yes, my name's Warner Fox. I'm a civil defense lawyer here in Georgia, have been for about 40 years, and I'm here to support the chairman's piece of legislation because of my practice. And I would echo what Mr. Milano said very briefly, is that I represent a trucking company. We hire a driver based upon a comprehensive framework that is the motor carrier safety regulations. It is an in-depth look back at the driver. It's not easy. And once we've done that and we hire that driver and we put him on the road and then he's in an accident, what's happening is the other side then says, well, let's look back 5 years. Let's look back 10 years. It puts a trucking company in a completely untenable position because they follow the letter of the law under the Federal Motor Carrier Safety Regulation, which again, if you look at those regulations, very comprehensive as to what a driver has to go through. But now the driver gets in an accident and we're judging him and the company based upon something that the Federal Motor Carrier Safety Regulations don't require. It is extremely unfair to have a trucking company have to be subjected to two standards. One, the Federal Motor Carrier Safety Regulation, and another one when they end up in litigation in Georgia where it's argued that their driver should not have been hired. So I think this legislation does one great thing, and that is it tells us what the standard is. This is the standard when you hire a driver. And it is very beneficial in that regard for the trucking industry because they know what they've got to meet, they know who they can hire and who they can't hire, and they're not going to be second judged later on. As to the GPS issue, the issue here is this. My clients, and I represent a lot of trucking companies, mom and pops, big ones, they use these systems to be safe. I mean, they put them in their trucks because they want to be safer because they're collecting data. And what's happening is that data is getting used for all kinds of different purposes. And I understand it's up to the trial judge. But what happens is some people will say, okay, let's go back 6 months and look at the data for the whole fleet. Let's go back a year and look at the data for the whole fleet or for a few drivers. And it's made the use of this data very difficult. And I have clients that literally are saying, maybe I should take these things out because I don't want to have to go back and be judged on the data that is in, that's old. So I think, again, this legislation as proposed would limit the ability to do that. Thank you.
You would agree that if, if somebody has a bad driving history, that would be relevant in a case, would you not?
I think it would be relevant up to the Federal Motor Carrier Safety Regulations. I mean, those regulations are designed by the Federal Motor Carrier Safety Regulation Administration to ensure that we have safe drivers. And so that's what we're looking at. And that is what, you got a 3-year look back. You look back for 3 years. How long are we going to look back otherwise? So I think complying with the Federal Motor Carrier Safety Regulations in terms of the hiring and continued retention of a driver is what should be the standard.
Well, then would you agree that this shortened look-back period would affect the rules of evidence and that we would have to amend it?
No, I don't think so. I don't think it's a shortened look-back period. It's the look-back period that the Federal Motor Carrier Safety Regulations require.
But when you get into a tort litigation, the character of the driver, how he drives, what his history's been like, may go beyond 3 years. And you're saying that that should be excluded?
I believe that what should happen, and I think the trucking industry agrees, what needs to happen is if you hire a driver and that driver is qualified pursuant to the federal motor carrier safety regulations, then he's qualified to drive. If we're going to put a higher standard on a trucking company, what is that standard? How far back are we going to judge the driver? Are we going to go back 5 years, 10 years, 15 years? That's the problem, Mr. Chairman, is there's no guardrail once you don't say that the federal motor carrier safety regulations control.
All right. Representative Bruce, good to see you back.
Thank you. How many lawyers in your firm?
Here in Atlanta, about 70.
70. Are you involved at all in hiring of the attorneys?
Yes.
How far back do you go to look at an attorney's record?
Depends on the situation.
Do you go back more than 3 years?
Sometimes we do go back more than 3 years.
So-
Other times we only go back the year where they, the last year of employment.
Okay, but sometimes you go back more than 3 years. And is the safety of the consumer more at risk with a lawyer or with a truck driver?
Well, that's debatable, sir. I mean, the fact of the matter is, from the perspective of hiring a lawyer, there is no rule or regulation promulgated by the state or the federal government. If they pass the bar, you can hire them.
But you as an attorney that's involved in the hiring, you're going to go back as far as you can to make sure that the person that you're hiring is going to be the right person for your firm. Is that correct?
I'm going to do it on an individual basis.
Okay, thank you.
Representative Hall.
Thank you, Mr. Chairman. As I've said before, if you've been here for a while, I don't work in this space, but I do work in the security space, which also has a very strong public interest component of individuals' monies. And for those that work in the securities industry, if they have a complaint, not even a finding, but if they have a complaint, it is on their record forever. And except for limited purposes where they can go through a procedure for expungement, but they have to prove that the complaint is false. And so I bifurcate these issues into, one, what is the threshold for hiring, which is one thing, and my understanding is that that sets the minimum standards for somebody coming in the door in terms of hiring, but then there are different standards in terms of liability. And I think most people would want to know if there is a record of negligence, recklessness, other things like that. And what particularly troubles me about this is 3 years isn't that long of a period of time. And if somebody had something that was particularly problematic, there's no way of sharing that information. And so I don't think that as policymakers we're picking out just one industry, because I just gave you another industry where this is true. And for those, there's not even a finding, it's just a complaint. So do you have any feedback to, I recognize that's more an observation than a question, but I do bifurcate these two issues of hiring versus liability.
Well, I would go back to the same thing. If I'm going to hire somebody as a truck driver, I've got a comprehensive federal regulation that governs what I have to do. If I have to do more than that, how far do I have to go back? I mean, do I have to go back 10 years? Because we certainly have circumstances where people have had a bad driving record 10 years ago, and then they're good. But under this, they're good by the time we hire them. They don't have anything on their record in the last 3 years. But are we going to allow that look back to be at 10 years, at 15 years? My problem is, where do you stop? And there is no guardrail currently as to where we start and stop. And I think this legislation provides that guardrail.
Okay. Any other questions for this witness? Thank you, sir. Appreciate it. Chairman, anything else you want to tell us?
You know, this has been an education for me in this committee today, and I have certainly enjoyed it.
All right. What's the pleasure of the committee?
Let's do pass.
Do I hear a second? No second.
I certainly understand, and like I said, I've learned an awful lot here today, and I want to thank y'all for your indulgence today. And if y'all, as this distinguished
You can
panel
make that
of
motion.
minds can come up with some ideas, just give me a call and I'll be back.
Hang on just a second. Representative Reeves? All right. Tell you what, Mr. Chairman, I'm going to declare that we're just hearing only today. So if there is a fix to this, we can come back and discuss that.
Please let me know.
Yes, sir.
Thank you, Mr. Chairman, ladies and
All
gentlemen.
right. Okay. 204. There you go. Yeah, I may do that, yeah. I'm hoping these others will go pretty quick. Okay. Yeah. All right, thank you. All right. Chairman Yura?
Thank you. Thank you, Mr. Chairman. I'll be brief. I know.
Which LC are you working from, by the way?
LC 442217.
Thank you. Go ahead.
And I'll be brief. I know cell phone charging levels are low and ladders are rather high. So I bring you House Bill 204. 204 passed last year, almost unanimously in the House. Got held up in the Senate a little bit, but this bill creates a municipal court clerk's council. And municipal courts like the Municipal Court of Atlanta, they have multiple sessions a day. Smaller cities may have just a court every couple of months. Despite the diversity of all these courts or municipalities, they all must follow the same rules and laws, and that's the whole reason for this bill. This will statutorily recognize the Municipal Courts Council, Clerks Council. This will give them the opportunity to apply for grants, also assist in standardizing the municipal court practices across the state of Georgia. This also helps them provide aid for seeking grants for the creation of municipal courts clerk certification program. As a former mayor, I know how important the municipal clerks are to each municipality, that they are properly run and efficiently run and apply justice equally. So this will make municipal courts better in the state of Georgia, I'm convinced of, and it requires no appropriation. It does allow them to apply for grants, however. And
So
I'll be
that
glad
would-
to answer any questions.
That would be the funding would be by grants?
That's correct, yes,
Okay.
sir.
All right. Representative Kelly.
Thank you, Mr. Chairman. Just real quick, who would fund the grants, Mr. Chairman?
Well, it could be a federal grant or it could be a state grant.
Thank you. And just second question, I remember this legislation coming through, and you said it came through the House last year. Is this
Yes,
the
sir.
same language as what we passed out of House last year?
It's the exact same language, sir.
Thank you. That's all I need to hear.
All right. You may. All right. All those in favor say aye. Any opposed? All right, your bill passed.
Right. Thank you very much.
Yes, sir.
Thank you, committee.
All right, I'm gonna pick another one that came out of here last year, House Bill 444.
Good afternoon, Mr. Chairman and members of the committee. Matt Reeves presenting House Bill 444, which is concerning notice of Liz Pendens. As Chairman Gunter mentioned, this bill in substantially the same form as it's in front of you in LC 49-1253 passed out of this committee as well as the House. It went to the Senate. There were some minor changes that prevented it from being finalized in the Senate. The Senate sent it back over to the House, and it got lost on a list of bills that were ready to be voted upon, but we just ran out of time on day 40 at the 11th hour. So House Bill 444 is back. This bill provides some due process to property owners regarding a Liz pendens that gets filed against their property that is either improper or otherwise defective. And a Liz pendens, it is a real estate filing, so it's not just a notice. It acts as tantamount to a lien or a cloud on title. It's an encumbrance on the property. It limits a property owner's ability to sell that property and give clear title, and likewise their ability to borrow money using the property as collateral with having clear title at that closing. Therefore, that would limit the ability to build on the property, to borrow on the property, and to otherwise use the property in many situations. So what this bill does is it sets out some specificity regarding Liz pendens. Liz pendens go back for many years under Georgia law, but this bill requires specification of the county where the property is located, a specific legal description on the property, the name of the parties to the suit, the time that the lawsuit was filed, the name of the court that the lawsuit's pending in, again, a description of the real property with specificity, a statement of the relief sought regarding the property, and that is commonly included in a Liz pendens, but that's by custom. This would give some statutory definition. And so it provides for notice. This is where we get into due process. The property owner would be entitled to notice of the notice of Liz pendens. It allows the property owner specifically to file a motion objecting to the Liz pendens and requiring a court to rule within 60 days on the motion. The court may extend that deadline, and it gives the court with four main options. Number one, find that the Liz pendens is improper and remove it. Number two, find that the Liz pendens is proper, but that a bond should be required, similar to a supersedious bond or many other bonds that are required under Georgia law. Third, find that the Liz pendens is proper and not require a bond for reasons that the court determines. Or fourth, the court can return to the issue of the Liz pendens at a later date during the pendency of the action. Section 3 of the bill places a duty on the party who filed the Liz pendens to remove it at the end of the case. Sometimes the case is over and there's no jurisdiction in the court and this Liz pendens continues to cloud the property. This would prevent that from happening. And so the reason this bill is needed is that presently there's no clear set procedure for a property owner to seek relief from a Liz pendens that's filed. And some courts will pay attention to the motions. However, many times things get caught up and the Liz pendens doesn't get addressed until the end of the case, and in the meantime the property is tied up and rendered unusable for a long period of time. This bill provides the property owner with a clear statutory right to be heard and to have due process if they believe that their property is wrongfully encumbered. There's also in Section 2 inclusion of Superior Court clerk fee relating to the filing of the Liz pendens, and that's the bill. It may sound familiar because it was approved by most, if not all of you last year, and glad to take any questions, Mr. Chairman.
Did the language you have in it now match what came back from the Senate for an agree? Is that where we're at?
We provided legislative counsel with the Senate adopted version that was ready to be voted upon, but ran out of time. They did clean it up, but there were no substantial changes made.
Okay. All right. Representative Scoggins.
Chairman Reeves, who carried this bill last year?
I believe either the chairman or
you didn't have much help, did you? Okay, this is a good bill. Thank you for bringing it. It passed last year overwhelmingly, didn't it?
It did.
Yeah. Thank you for bringing the bill.
Thank you.
All right. Representative Silcox.
No, thank you so much for bringing this, having closed a number of transactions where this was just an outstanding issue. I think this is really a good bill, and I think it's fair, gives notice, like you said, and it's kind of some due process there, and I do think it will help in a lot of transactions. Thank you.
Thank you.
All right. What's the mood of the committee? All right, got a motion, got a second? Second. All those in favor say aye. Any opposed? All right, the bill
Thank you
passes.
so much.
Thank you. House Bill 254. He may have it, yeah.
Thank you, Mr. Chairman. Thank you, committee, for letting me come. House Bill 254 is being carried by David Jenkins, but he is in another committee at the time, so I am going to cover this one for you. It is HB 254 LC 491340S.
Okay.
And we did go through subcommittee, and I will explain what the change is to that. This bill was brought forth to address a few different issues that have presented themselves over time concerning the legal organ. In Section 1 of this bill, it addresses a need that's arisen in a county due to a legal organ being needed when none fit the current requirements. So Section 1 states that in the event that no otherwise qualified journal or newspaper has a paid circulation of at least 100 copies per issue in the county, that they may designate a newspaper that does not meet those current requirements. It's considered an interim, so it has a weekly circulation of 100, but does not require the paid portion. So the key on that was, and at least in the county that it has happened so far with, the legal organ was removed and basically closed. And they did not have a paid subscription of 100, but they did have some free newspapers that did have a 100 member draw, like they had subscription basically, but it was a free newspaper. So they could use that. It says such interim designation shall terminate in the event that another newspaper meets that qualification. So this is just in basically an emergency situation to be able to use one of your other local newspapers. In Section 2 is what we added. This is the substitute piece that was added. It came a little bit later, but we have not heard any disagreement on this, and we've run this basically by the same groups that have spoken in the past, which would be the Georgia Municipal Association, the Association of County Commissioners, and the the Press Association. This is a section that just increases their rates. The rates for the legal organ have not increased since the 90s, so this is a small but significant increase for them, and we're in agreement that this is quite simple. So for each 100 words in Section 2, not more than the sum of, and we changed it from $10 to $15 for 100 words, and then for each subsequent insertion, not more than the sum of what was $9 is now $14. And then we go into Section 3, and Section 3 is really kind of the meat of where this started. We were having some issues in communities where the legal organs were not actually, there were errors made either in what was being printed or it was not printed at all. And because the legal organs throughout the state, some have gone to what maybe once was daily is now weekly, and it would have been maybe even a week before it could be reposted. This Section 3 does not change the requirements of using the legal organ. It does not change that requirement at all as it is today, but it creates a fail-safe in case there is an error or omission. And in Section 3, to do that, it just requires, it allows for and it labels websites. So in the definitions are websites, but it gives the opportunity for your county government to post on their website and for that to count as the original day. So in Section 3 we have, I've got some, let's see, my notes are in a little bit of back order here, but it allows them to post. It actually asks the newspaper to, within 2 days, post on their website if they noticed an omission or an error has occurred. The newspaper legal organ, the current legal organ, also posts on the statewide website that is used, and that is the common site. And otherwise, what happens with this is the correction, as stated within this, shall be considered as having been correctly published if we've done that, if we've posted it on our county or municipal website and it's been posted on the newspaper's website. It was unanimous in committee, again, except for Section 2, which is the new section which increases those rates in subcommittee, and that's the gist of the bill, and I can answer some questions if you have any.
All right, Representative Kelly.
Thank you, Mr. Chairman. So when did Section 2 get added in subcommittee?
No, it was added today.
Okay. And is it true that this increase will apply to every legal advertisement that gets ran?
Yes.
Okay. Thank you.
Any other questions? All right. What is the desire of the committee? Second. Motion and second.
I have a amendment, Mr. Chairman.
Yes, sir.
Mr. Chairman, I move that we strike section 2 in its entirety, lines 30 through 39.
All right. Do I hear a second?
It didn't get vetted in subcommittee, Mr. Chairman. I think it's one of these things that gets passed on to our citizens at a time when I don't think that we should be encouraging this type of inflation.
Do I hear a second to the motion to amend by striking section 2? All right, motion and a second. All those in favor say aye.
Aye.
I'm sorry. Question?
When's the last time that we raised these rates?
98, I believe, was the last time.
I would think that it's time.
Okay.
If I may respond as well, we've not had any opposition come forward to this, and it's certainly a fair and and I personally have reached out, of course, to my own county administrator as well as my sheriff to find out, if there's any, if I could find any opposition. I have yet to find any.
All right. Representative Reeves.
I did. Yes, ma'am.
Were Representative Jenkins and the other co-sponsors okay with that amendment?
Yes, and so I'm just reporting this for Representative Jenkins. Yes.
All right. Representative Kelly.
I would say, Mr. Chairman, I just encourage members of this committee. These I run a lot of these through my law office. Constantly things when people are just trying to handle an administration of an estate. When you're talking about someone who's trying to just sell their mama's property after they've passed away, and lawyers don't eat these fees. They get passed on to people usually at their hardest times in life. And, I would just encourage us to be very cautious on that. There's a reason why, since 98, this as a body, we decided not to increase it. And right now I would just, ask and say this isn't the time to do it now either. And so that's why I would encourage everyone to support my amendment to strike this language that didn't get considered in subcommittee.
Okay. All right, we have a motion and a second to the amendment to take out section 2 of the bill. Any further discussion? Hearing none, all those in favor of the motion to amend, say aye.
Aye.
All those opposed? No. All right, amendment fails. So we're back to, I think I had a motion and a second to passage of the bill, or did I? I don't remember. I think I did. By substitute, right. LC 1340S, excuse me. All right. Any further discussion? All those in favor say aye. Aye. Any opposed?
No.
One opposed. Bill passes.
Thank you, sir.
Okay.
Thank you, committee.
All right. Are you going to wait around for the bill, for the sheet? Yes. Okay. All right, we are adjourned.